Good morning, everybody. Happy Tuesday. Welcome to the Courtroom Files Live. Apologies, I'm a minute or two late to the party today because there was some last-minute jockeying for position with the judges. We're going to start, though, with Judge McNally, Judge Dad, up in Michigan.
Secondly, he was at a funeral and provided proof of that in this the counseling session.
All right, sir, if you plead guilty here, you could get 10 days. Do you understand that?
Yes, sir.
Did you sign, read, and understand the advice of rights?
I did.
Mr. Zelnick, do I have an appearance from you, sir?
Sent another one in by computer last Thursday.
Lisa, do I have one?
Yeah, it should be in there.
Okay,
And I represent him on the original charge.
all right. So if you plead guilty here, you understand you're giving up all the rights on the advice of rights.
Yes, sir.
Did you sign that document and read it and understand it?
Yes, sir.
All right, any questions on your rights?
Not on my rights.
As to count one that you failed to appear for the court work program on June 21 of 25, how do you plead?
Guilty.
Did you fail to appear for the court work program on that day?
No, sir.
Wait, hold on. You appeared and then believed you were excused to go test, and then you didn't come back to work. Is that correct?
Correct. I explained to the man and he goes, go ahead, we can reschedule you.
You did not appear, you did not serve the day on the court work program, correct?
That's correct.
As to count two that you failed to appear for the relapse prevention group at the guidance center between June 9 and June 14, how do you plead?
Guilty.
Did you fail to appear for the relapse prevention program between those dates of June the 9th and June the 14th?
It was a one day. You didn't appear between that time period. Is that correct?
Yes, sir.
What day didn't you appear?
It was the day of the funeral. Is that right?
You know, the 17th, I believe it is.
Well, they're alleging between June 9 and June 14.
I missed for the funeral on June 26, 2002.
They're not alleging that. They're claiming you missed between June 9th and June 14th. June 26th has nothing to do with that. I don't think there's any violation. Miss Jamie, your name?
Sadie, Jamie, probation.
All right. So this has nothing to do with the funeral, this count two, correct?
Correct.
Which day did he miss? Maybe he's got the wrong dates.
Can
You
you,
didn't appear. If they say you didn't appear the other day.
can you enlighten me?
Yes, Your Honor. I received an email from the guidance center supervisor that David missed group between 6/9/25 and 6/14/25
And how many times did he miss during those dates?
once.
What day was that?
They did not give me the specific date.
All right.
It would be the Friday you missed. So whatever week it was a Friday you missed.
I
I
believe
only
that's
go on
correct.
Fridays.
Hang on a second. Let's just slow down. June 9th was a Monday, June 13th was a Friday.
June 13th. Does that sound right?
June 13th.
Why didn't anybody force you to plead guilty?
No.
All right, I'm gonna accept your guilty, please. Why didn't he show up? Tell me what happened with the court work program and what happened with the relapse prevention, Mr. Zelnick. Why didn't he show up on the 13th? And why did he leave the court work program?
Mr. Ford, you appeared at the court work program and was unable to give a blood sample or urine sample before the program. Is that correct?
Yes, sir.
And you asked the court program operator, is he under oath, Judge, or are you gonna just take his word?
Say that again?
You'll take his word for it. He's not under oath, but you'll accept his statements here?
Well, yeah, I already took his plea. I
So,
mean,
Mr. Ford, then you believed you were excused from the program to go and test, is that correct? So you didn't work on the program that day?
That's
Did you go
correct.
back and give a drop or a sample that day?
I did.
There's enough there. Now, whatever date they said, you missed a Friday, and you may have the wrong dates because of the funeral, but you believe if they say you missed the 13th, then you missed the 13th of June.
Well, it could have been, I called and talked to Alex one day to be excused because I had a wash machine that went out for a month.
was that on June 13th?
That was on Friday the 13th.
All right, well,
And the wash machine repairman, I had to be there for him to get into my house because I didn't have a wash machine for a month.
What time was your appointment at? Your your relapse prevention program?
I get there at 10 o'clock.
Well, why didn't you make sure that the washing machine mechanic, so to speak, came after that or before that?
I asked and they had no openings. I had to wait for 2 weeks to get somebody to come to my house.
That old big tag repairman. Well, Judge, that was a bad Friday the 13th. I think we resolved.
Who are you claiming from the court work program that let you go test and told you that you didn't have to come back?
It was the man that was running.
Well, wait a second. Let's slow down here. The court work program on Saturdays, it runs from June 6:30 in the morning. I'm sorry. The testing site is available 6:30 to 9:30 in the morning, right?
Correct.
Court work program goes until what time?
1:30.
All right. If you went down the street at 9:30, why in the world would you have thought you didn't have to go back?
Because the man told me that I can be rescheduled for another appointment to work on a
Who
Saturday.
was it?
I don't know his name, sir.
What did he look
I
like?
had my vest on.
What did he look like?
He was a shorter man,
Shorter man.
kind of.
Well, he's not the supervisor.
And he goes, Mr. Ford, you were the first one here. Let's follow me, let's get you signed out right now. And, I gave him my vest and my gloves and I left. He says, we'll reschedule. I wouldn't have gone if he didn't tell me that, sir. Ever.
All right. What else do you want to say, Mr. Zolnick?
Judge, I presume that he's up to date, no positive tests, but otherwise he's in compliance. This is his first series of violations. Mr. Ford, as the court may recall through the case, is undergoing emotional stress due to the passing of his wife and his mother at the same time. And I perceive just a slow, even though he works, he's an intelligent man, he's got a daughter who's a school teacher at Courtroom. I think there are some developing cognitive issues where he needs to focus better on what needs to be done.
Anything else?
You pretty much agree with that, right?
Yes, sir, I told Sadie the other day I'm not sure what day it was, that my wife did all of it. I never had to plan a vacation because my wife did it all, so I'm trying to get back, I'm trying to get on the positive side of getting everything, and I have everything scheduled. I have a schedule right in my phone. And I have a schedule that Sadie gave me that I'm working out of also.
What do you have to say?
Mr. Ford, he's compliant everywhere else. He goes to testing, he comes to meetings with me, he comes to status review. There is some issues with taking accountability and being responsible for completing the things that he needs to do. It's been kind of a pattern with him.
You know, we were younger, Judge, we tie a string on our finger to remind ourselves. Maybe you need to put some strings on your fingers before.
So what do you think?
I would recommend that he pay court costs and have an extra day on the court work program. And then Mr. Ford would also need a new date for his community service because that was due on July 1st and he did not.
How many hours did I order on that again?
40.
He ordered,
How many did you complete?
Well, after tomorrow, it'll be 33.
Your Honor, I have proof of 12.
So you gotta get us the proof.
That's down at the church.
All right.
Your Honor, before you conclude the matter, he's preemptively advised you of missing a session because of a funeral. And I don't know if probation's aware of that. I'd hate to bring it back on another one. Let you know now that
You're not gonna violate him on that.
No.
Nobody's gonna violate.
Well, I want to bring the medical examiner. We brought the big tag repairman. We brought in Friday the 13th. I'd like to move on.
Sir, one additional day on the court work program plus the day that you missed. Pay $100 in costs. All community service all community service has to be completed by July 31. So you have to provide us proof that you've got all 40 hours done by July 31. Additional costs of 100. Can you pay those today?
Yes, sir.
Well, you said you're close, right? You said you got 33 hours.
I'm
Done.
close. Yeah, I'm gonna work. The Deacon Pat down the street at the church said he was gonna try 5 more hours. So I can
Well, where are you gonna do the other, you said you're gonna have 20, did you not say you were gonna have 33 done after you did certain hours? Where is that at?
down at the church.
How many hours are you doing tomorrow?
8,
All right,
27. And I might have more than 33 hours.
okay, well, that's fine, but the point is that you looked like that was an impressive sentence, and if you've got 33 done by tomorrow, you should be able to do the other 7 by the end of the month, right?
By the end of the week, sir.
Okay, well, I'm giving you till July 31, and we're gonna give you 1 additional day on the court work program.
Thank you,
You
Ron.
can pay your costs now, I wish you well, thank you.
Thank you, Judge.
Thanks a
Great
lot,
to see you today.
thanks a lot.
Good morning once again, everybody. Welcome to the Courtroom Files Live. Happy Wednesday. I've got my eyes on 14 different courtrooms at the moment. There's a lot going on. We'll continue to ride with Judge McNally, though, for another hearing or two before we switch to somebody else. And Win, good morning. YouTube was acting funny and wouldn't let me type. There's YouTube weirdness this morning, Win, but good to have you here.
On January 6th, I arraigned you for failure to pay 133, pled guilty. I told you to pay by January 27th. This is July the 8th. On the other case, you tendered a plea of guilty to failure to pay 193. I ordered you to pay by February 17th. This is July the 8th. I also told you to come and talk to me if you didn't have the money. Did I do that or not?
I believe you did, but
I'm sure I
pretty
did.
sure it slipped in my mind.
Slipped your mind?
Yes, sir. In all factuality, I was no lie to you.
I'm sorry?
I said, I'm not even gonna lie to you.
Well,
It
that's,
slipped my mind.
it slipped your mind.
Yes, sir.
I wish it would slip my mind to pay my tax bills that I just got. You know that? I'm serious. Now listen to me.
Okay, yes,
It's
sir.
time to grow up. How old are you?
I'm 23.
Well, what are you doing?
Honestly, I'm paying my own bills.
Where do you work?
I just started actually like
When?
2 weeks ago.
What were you doing before that?
I didn't have a job.
Why not?
My car broke down. I literally just got a ride up here today, I promise you. Like, I have a son and everything. I own my own house.
When did you last work before starting the painting work 2 weeks ago?
A good 6 months to a year.
So you couldn't get your car fixed because you didn't have the money.
Yeah.
Does it make,
Basically,
hang
bro.
on,
Yes, sir.
does it make any sense to you that you wouldn't find a job and figure out a way to get there?
I've kind of been trying.
Kind of been trying.
I understand. I know it seems like I'm
No,
not in as much as I could be, but I honestly been trying as much as I can.
where'd you apply?
A job called Single Source. I actually paid.
I know, but where'd you apply in the last 6 months to a year? It sounds like it's been longer than.
McDonald's, Wendy's, every fast food you can
Where?
think of.
Where?
E-course.
Wait, slow down. Where in E-course or on E-course?
On West Jefferson. I live right off West Jefferson.
You applied at McDonald's?
Yes, yes.
They wouldn't hire you?
No, sir.
Where else did you apply?
I've also applied at Wendy's,
Where?
Burger King, Subway.
Wait a minute,
Okay.
come on, slow down.
Wendy's.
Wait, Wendy's where?
Wendy's in Gibraltar.
You were gonna somehow get to Gibraltar without a car? Now listen to me.
That was.
Hang on. You didn't have a car, so you couldn't get a ride and you couldn't get to work, and you live where?
I live in Eagle.
All right. Does it make any sense that you were applying to Gibraltar? Whoever's got the phone, it's got to leave the building right now, please. Got to take the phone out of the building.
Whose phone went off?
Sir,
Gotta go out.
in the white t-shirt, whose phone went out?
Yeah, let's
It might have been mine, sorry.
Got to take it out of the
Guys,
building.
make sure your phones are off.
You sign.
Does that make any sense?
No, sir.
Do you know how much you've just convinced me that you haven't been trying?
I understand.
I know. Now look, if you want to go your whole life in poverty, that's your choice. But don't come up here and start telling me stories. All I asked you to do, if you didn't have the money, call the court, we'd go on Zoom. You couldn't even be bothered to do that, even though you're sitting around the house for 6 months to a year. Now look, whether you end up in poverty or not, when you're 25, 35, 55, it's no skin off of my neck.
Understand.
But figure out a way to make a living. Really.
Yes, sir.
I don't understand why people do this to themselves. You couldn't even be bothered to call the court and talk to me and say, Judge, I don't have the money. But you're just telling me stories now. I don't want to hear stories. Listen to me.
Yes, sir.
I hear stories every single day. I'm surprised I don't lose my cool a lot more. I get tired of having people stand there and lie to me. I'm not sure you don't deserve to go to jail today. How much money you have with you?
No.
How could you have money? You don't work.
I just paid all my money towards my bills.
Well, you've only been working for 2 weeks of the last year. How could you possibly have money unless you're a trust fund baby and they're giving you a couple $100,000 a year? This ticket has been outstanding now for 10 months. I'll give you one more chance, but if you do this again, I'm sending you to jail. Do we understand one another?
Yes, sir.
Are you sure we understand one another? Are you sure you understand that if you don't have money, that you at least have the courtesy of either coming in here and talking to me or calling on up and saying, I need to talk to the judge about an extension?
Yes, sir. But I give you my word.
My word. You know how many times I've heard people give me their word that they don't follow through with?
2 weeks, sorry.
And I've never had anybody come in here and tell me in 30 years and 7 months that they're coming back. You tell me when you can pay the speeding ticket. Well, you owe $38 on the parking. When can you pay? I'm gonna let,
Next week.
Are you sure?
$38 next week.
slow down,
Yes, sir.
slow down. Are you sure?
I'm 100%.
I can give you more time if you need more time.
I'm about, well, just in case, how about the week after? Just in case. But I'm pretty sure I could have both tickets paid by next week.
Okay. I'm gonna do better than that. Pay this parking in full by July 25th. That's 2.5 weeks. And I'm gonna give you on the other case that you owe $193 on. Did you say that you own a house, right?
Yes, sir.
Do you have any kids?
Yes, sir.
I thought you said
My
that.
son back there.
Where?
He's like, yeah, let's pick him up. That's my son right there.
Good.
That's what I'm saying. I honestly
You don't want him to be in
goes
poverty.
towards that.
You don't want him to be in poverty, right?
No, sir.
Okay, I'm gonna give you until August the 8th to pay the other one. Given the fact that you told me you could pay both by next week, I've been more than fair. Now, if you don't have the money, come talk to me, call up, I'll go on Zoom, I'll give you an extension. I hate this when people ignore
Yes, sir.
courts and then come in here with stories. Good luck. Thank you. Stop it. You owe it to that child to provide a roof over his head. Damon Anthony Shelton Jr., 25W837988. Morning, Lieutenant. Name, sir? Good, your name? You owe 309.
Yes, sir.
How much do you have today?
I don't have anything today.
Where do you work?
I don't have a job.
Why?
I got fired.
When'd you get fired?
I was working for a cement company. I actually do cement. I was making a good amount of money, actually, $25 an hour. The owner, he thought that I wouldn't work $25 an hour, so he told me he would pay me less, but it wasn't enough to pay my bills, so.
So you quit or you got fired?
No, I told him that I couldn't take less than what he initially.
Why didn't you get another job before you took him? You couldn't get, listen, it's your life. Just tell me when you can pay this.
I came here to make a payment plan.
Tell me what your payment plan proposal is. How much can you pay per week?
I can pay, this week I can pay $50 to start off, and then every other week after that, I can pay $30.
You have 50 now?
No, Friday.
You pay 50 by July the 11th,
Yes, sir.
then 50 bi-weekly beginning July the 25th.
I said 30.
I'm sorry?
I said 30.
I thought you said 50 this week, and then you said 30?
Yes, sir. Then I said 30 bi-weekly.
All right, I'll let you do that. You gotta find a job.
I've been looking, if y'all hiring up here, I work up here.
Pardon?
I said, I've been looking for jobs every single day. If y'all hiring up here, I work up here. And I mean that with everything in me.
I just don't know what we would have for you.
I'm a jack of all trades. I do a lot of stuff.
Do you? You're a maintenance guy?
I can be.
All right, look, you pay 50 by Friday. You sure you can do that?
I'm positive.
30 bi-weekly beginning July 25th.
Yes, sir.
Now, you just heard my conversation. If you don't have the money, no problem. Call the court, we'll go on Zoom, honor before a due date that you don't have the money on, or you can come up here, honor before the due. I'll give you an extension. I don't care if we have to do it 87 times, really. Just don't ignore me.
I'm gonna stick to my plan that I told you, sir.
All right, I wish you well. Good luck. Guzanik, I'm sorry. Edward Hewitt Guzanik, 25T644886, 25F243454. Your name?
Edward Kazanik.
Where do you work?
I'm unemployed right now.
Why?
I got fired a couple months ago.
Why are you guys getting fired?
There was a argument between two coworkers and they fired both of us.
Where were you working?
Ganthy
Where?
Automotive.
Oh, I see. Okay. And how long ago did you get fired?
3 or 4 months ago.
Why aren't you working?
I have interviews, later today for Subway and then I have one tomorrow at, Temp Farms.
$40 bi-weekly starting July the 25th. You'll pay that on 886, and then you pay 40 bi-weekly on the impeding. You don't have any money with you today?
I do not, but I can pay it in 2 weeks when I get my last check.
You owe 213 plus 237, you owe 450.
Yes, I know.
Tell me you can pay all of this in 2 weeks?
Yes.
I'll tell you what, you pay the impeding traffic by July 25th. That's 237.
Okay.
And then I'll still let you pay 40 bi-weekly beginning July 25th if you don't have all that money on the speeding charge, okay?
Okay.
Go find a job. Life is easier. Life's tough, right? I think it is. It's not easy. Good luck. People against Jacob Robert Zarebic, 25B1481318 in B.
Hello, Your Honor. Jacob Roberts Rubik.
Okay, good morning to you. You have 2 technical violations previously. You are on probation for operating while impaired on 8131A and for the drug charge on 8131B. You have 2 technical violations. Now, you're now on probation for, I'm sorry, you're now on, in court on a violation probation. It alleges that you failed to refrain from consuming alcohol or drugs testing positive for cocaine. That's count 1. There is a second count here. You understand the charge? They think you did that on June the 9th. which ironically was the same day you were in here pleading guilty on another charge. Count 2 on both of these violations alleges that you provided a dilute sample on June 30. 5 samples, all dilute. Hang on. So if you plead guilty, or if you're found guilty here, given that you have 2 prior technical violations, you could have your probation revoked, and you could be incarcerated for the maximum provided by law on these, which is 93 days on the impaired charge, and which is, this is a misdemeanor under local ordinance, 90 days on the drug charge. Do you understand that?
Yes, sir.
All right. Did you sign, read, and understand an advice of rights form here today?
I did, Your Honor.
If you plead guilty, you'll be giving up all those rights, and there will not be a hearing. Do you understand that?
Your Honor.
You do have the right to a lawyer, and I'm going to be glad to give you one today at public expense if you want one. Would you like a lawyer?
No, sir, Your Honor.
Are you sure? Maybe you need to get one.
That's a good thing.
I think you should. I'll enter a not guilty plea for you, okay? I'll enter a not guilty plea. We're gonna have you meet with the lawyer today, and you'll come in front of me today, okay, John, for your hearing. You understand all of that?
Yes, sir.
So you go out in the hallway, again, I'm entering not guilty pleas on both counts. You'll meet with the lawyer, and then you'll come back in front of me, any questions?
No, sir.
Okay, thank you very much, and good luck. All right, so I'm gonna move you guys out of here the quickest I can. So I want Tyler Olson at the podium. Tyler Lee William Olson, 25W839-056, up to the podium, or is he on Zoom, Lisa?
It's on Zoom, Judge.
And then I could have Craig Brown seated over at the table, Ahad Siddiqui seated at this table, my right, your left. Mr. Tyler Lee William Olson, 25W839-056. Is he coming in, or?
Well, they figured that out. I want to point out that the last time I got on the mic, I said it was Wednesday. I want to give you the day back. It's Tuesday. Thank you all for pointing that out to me in the chat. When you work for yourself, days blend together, something fierce. So yeah, Tuesday, I grant you back one day.
What'd you say?
I need your name.
Tyler Olson?
You are not in a moving vehicle, right?
Yes.
You are or you are not?
Wait, what'd you say? Sorry about that.
Are you in a moving motor vehicle?
No, sir, I'm not.
You're going to plead to impeding traffic, right?
Yes.
To that charge, responsible or not responsible?
Do what?
I'm asking you, how do you plead to impeding traffic? Responsible or not responsible?
Responsible.
Plea is accepted. 185 is your total. I'll dismiss the commercial vehicle speeding charge. You can pay that today?
Would I be able to pay that tomorrow?
Yeah. I'll give you until tomorrow. You go right on 33court.com and make your payment, okay?
Okay, is that the email, is that the address that's also on my ticket?
I'm sorry, I didn't hear. Wait a minute. I didn't understand your question. Here are your questions.
Is that the same, yeah, the www.33court.com that's on my citation as well?
You're going to go on 33court.com with your case number, and you can make your payment by a credit card or debit card.
Okay.
Okay?
That works.
All right, best of
Alrighty,
luck.
thank you, sir.
You're welcome. Craig Price Brown, 25B148732. Your name, sir?
Craig Brown?
All right, so you're going to plead to 1 to 5 over, correct?
Yes.
To that charge, responsible or not responsible?
Responsible.
All right, I'll accept the plea. The period of yields dismissed. 195 is your total. Cash your end of the hall. Best of luck to you.
Thank you.
Ahad Mahmood Siddiqui, 25B148695. Your name, sir?
How's it, Your Honor?
Good morning. You're going to plead to impeding traffic, true? To that charge, responsible or not responsible?
Responsible, Your Honor.
All right, you got to slow down. Come on, 79 or 45, right? Slow down. 160. Cashier into the hall to your right. Good luck. Ashley Marie Ballinger, 25B148651. And I'd like Willie Johnson and Michael Ponaworski seated at the table here. My right, your left. Good morning. Your name?
Good morning, Ashley Mary Ballinger.
So you met with them. You're going to plead to impeding traffic, right?
Yes, Your Honor.
All right. You got to be careful, okay?
Yes.
Responsible or not responsible to impeding traffic?
Responsible.
I'll accept the plea, dismiss the original charge, $200, cashier into the hall to your right. You're all set.
Okay, Your Honor, I just wanted to ask you, can I get a little bit?
Sure, how much time do you need?
Maybe just like the month, you know what I mean?
No. What
By
do
the
you-
end of the month?
Yeah, I'll give you till July 31.
Perfect.
If,
Thank you
if
so
you
much.
don't have the money, you call the court, we'll go on Zoom, or you can come up here on or before your due date, and I'll be glad to give you an extension, all
Thank
right?
you, Your Honor.
Best of luck. Willie Johnson III, 25B148785. How you doing, sir? Your name?
Willie Johnson, third.
Good morning. You're going to plead to impeding traffic, right?
Yeah.
To that charge, responsible or not responsible? All right, gotta be careful, okay? 170. Cashier under the hall to your right.
You know, some extra time.
How much do you have?
Maybe about a month through.
A month? Where do you work?
Right.
You're making $32 an hour. What are you doing with all your money?
Whoa, you know, cost of living going up now, so I need a little time. That's okay.
I'll give you some time.
Appreciate it.
But think about what you're doing with your money. You're probably making six figures, at least. Huh?
Maybe,
Yes?
something like that.
Do something with your life, will you? I mean, keep your money.
Time to.
Okay. August the 7th, I'll give you to. If you need more time, call the court. We'll go on Zoom or come up here on or before that date. I'll give you an extension. Best of luck. Save your money. Good luck. Michael Pine.
All right, let's change it up a little bit. Let's go to Texas. We'll say good morning to Judge Stevens.
Yes. Present with your attorney, Mr. Adams, and the state's attorney. You are charged here in this case with the first-degree felony of burglary of a habitation. And it states, among other things, that on or about April 2nd, 2025 in Jefferson County, Texas, with the intent to commit the felony offense of aggravated assault with a deadly weapon, you intentionally or knowingly entered a habitation without the effective consent of the owner. And that's signed by the grand jury foreman on behalf of the grand jury. If convicted of a first-degree felony, you face no less than 5 nor more than 99 years confinement in prison or life imprisonment, and a fine up to $10,000. So you have to understand this is a most serious case, has serious applications to it. All right, what is it? The initial appearance?
Yes, sir.
All right, what issues do we need to bring up, if anything?
I think when you read about the law, the effective consent of the owner of the premises is the father of a child. And I understand he does not want to pursue charges at all. He's done an outrageous non-prosecution. And she's anticipating a child for him as we speak.
That's
Hold on for just a second.
correct, Your Honor, and I did adjust my offer accordingly. However, it's also alleged that the children were there with her. She brought them along with her at the time of the incident, that she busted into the house and attempted to stab the other implanted girlfriend.
Well, here's what the probable cause affidavit says from the police. So they're dispatched to 6836 Bexley in Groves. and spoke to Stephen Alexander, who stated his ex-girlfriend forced entry into his residence by damaging the front door, then entered and attempted to cut and stab him with a knife she was holding. And the defendant was also calling for his new girlfriend to come out of the bedroom, as he believed she was attempting to assault her with the knife as well. He took the knife from the defendant and she cut herself attempting to get it back. Also, she had 2 children with her inside the residence when she was fighting with them. That's really great for kids to be able to be a part of that and see that. She and the children left the residence before the police arrived, but she was later located hiding nearby. The children with her were 7 and 8 years of age. What an environment they must have. There's no way to role model, man. All right. Well, at the time, he wanted her charged. He's the one who called for help and called for the police to come out.
But not now.
Yeah, I know. So everybody spends a lot of effort, time, and money into going out and taking care of people's love lives that they can't handle themselves, and then put people in harm's way. And then later on, they get to manipulate. They'll call the police, and then where they're kind of tired of it, then they decide, well, we don't want this anymore. You don't have control over the situation, man. When you call the police, it's out of your hands. It's in other authorities. People who are going to act responsibly are going to be taking over the case. Anyway. Yeah, the criminal jurisprudence, the criminal courts are not here to work on your whim. They're here to see justice is done and for the safety of the community. And here you need to do far better work on being a role model for little children, because they're going to emulate their parents, and what's going on here are bad examples. All right, we're going to put in an announcement next. Okay.
Thank you.
Be set for announcement next. Let me see. Let me put something up, please. Perfect. This is it.
Yeah.
Thank you. Thanks. Get a reset.
Thank you, Jim.
Justin Woods. Justin Woods. You're Mr. Woods? You're
Yes,
Justin
sir.
Woods?
Yes, sir.
Where's your attorney?
He's on his way.
Okay,
On a little
okay. We'll wait for him. Okay. This is gonna be disposed of today, isn't it?
To my
It
knowledge.
says plea hearing.
We'll see, Judge.
Well, we'll see. Mr. Linder, Ronnie Linder, come on up. I think your attorney is in the hospital. Is that right? That's what it's showing. He's got some medical issues he's dealing with.
Right.
Have you been keeping up?
Yes, sir. And I said, I've been trying to, but I said, I was going to show up. I'm
Sure. That's awfully good of you. Thank you. And we're gonna take care of you. All right. We'll just have to reset this. Let me ask you a couple of things because of the nature of these cases. I guess you have an interlock device on any vehicle you operate. You're not operating a vehicle. Well, that's a way to avoid trouble. Who drives you around when you need to go somewhere?
my coworker or my brother.
Okay.
Yeah.
Well, that's important to do. Don't get caught
Yes.
in a vehicle without license, without interlock device. If you do, that'd be trouble. Your bond would be revoked. It would be like your head would swim. It would be that fast, and you'd be in jail, and we'd have to wait it out in jail until this thing gets disposed of. I'm going to reset this a couple of weeks. Okay.
Doesn't sound like his health will be
Huh?
doesn't sound like Mr. Doyle's health will be responsive in that time frame.
Oh, it will be, you said?
Will not be.
Okay. Well, there's some things everybody seems to know some things I don't know, and that's not abnormal. That they're keeping up with some things that I'm not in the loop on.
Maybe 30 days, Judge. I think we'll have a better picture in that time frame.
Okay. You paid him some money, I guess.
Oh, yes.
Okay.
We'll be able to know what's the right next step at that stage, Jeff.
You probably ask them what's that thing.
I was looking, so it's going on a year old. All right, let's see where things are in 4 weeks. We'll know better whether we have what direction we're gonna head in, okay?
Yes, sir.
In 4 weeks, we ought to know where Mr. Doyle's health direction is. Okay, thank you.
Yes,
Get it resetting.
Yes, sir.
Luke Cooper. Who is your attorney,
Brian,
sir?
Mr. Brian. And
Mr. Bryant?
it's Brian. Brian, sir.
Oh, Ryan. Ryan, are you here for him?
I'm not good.
Good work. Did you hear Reagan? Well, she just jumped right out. I don't have anything to do with that guy. I
understand.
Judge, I have to tell you something when you get a second.
Okay, well, he's between contestants there. Let's go to Wade Mercer in Florida. Well, he does first appearances.
He's at the Jackson County Jail, and in the courtroom here in Mariana, we have Mr. Jake Mitchell, the prosecutor, and I do not see Calhoun County lit up.
Hey, Judge
It's
Mercer,
8:34.
they just
Calhoun
told me
County
they're
has two
having
cases.
connection issues. So they're working on it real quick.
Is this Ms. Schuler talking?
Yes, sir. They're Calhoun's having connection issues, so I'm having them restart it.
Thank you, Ms. Schuler. So we'll come back to Calhoun County in just a moment. But ladies and gentlemen, we only have 2 cases in Jackson, I believe. So let me do Jackson first. And Corporal Drown, can you see and hear us there in Jackson County?
Yes, Your Honor.
Great. In Jackson County, our first case is Javarius McGriff. Mr. McGriff, good morning. Mr. McGriff, you're here because you've got a couple of issues going on. Good morning. You have a new failure to register as a sex offender charge in Jackson County. In addition to that, you're already out on bond on an old case that's been pending for a couple of years. That's 23-381CF, Mr. McGriff. And in addition to that, you're on Bay County probation, felony probation out of Bay County in 21-591CF. Mr. McDaniel, anything on behalf of Mr. McGriff?
No, Your Honor.
Mr. Mitchell, anything?
What were those case numbers again? That he's
Judge,
on bond and on probation?
Let me give Mr. McDaniel, Mr. Mitchell these case numbers. He's on bond in 23-381CF.
381.
It's a 2-year-old felony case in Jackson County that's still pending. And he's on probation in Bay County 21-5191. CF.
9-1.
Mr. McDaniel?
Judge, just take into account, I don't know how much you take into account of this, but I guess, these registrations are kind of complicated sometimes, and this is his first time having to do that, and it's supposed to be the month of his birth date, which was 2 weeks ago in June. I know the sheriff's offices, wherever they do, it's kind of I don't know if you want to take those things. What do you want to say?
I'm just sorry about that. It just slipped my mind, Judge. That's all. It just slipped my mind.
I mean, it's.
Mr. McGriff, if you weren't on bond and on probation, it'd be a little different analysis, but not a whole lot I can do when someone's on bond already. I'm not sure why your case is still pending after 2 years. That's unusual for that type of charge. It's not that serious of a case, at least based upon the charge. So maybe that case can get to trial or get dismissed or get pled soon. But it's still pending after 2 years, and you're still on bond and you're on probation. Are you here on this case, ma'am? Okay. First of all, we need to get the child out of the courtroom. Okay. Please. Is that his son or his child? Yeah, he has no business. How old is that child? He's 7. He has no business being in the courtroom seeing his dad in jail. Okay. So wait just a second. Mr. Gibson, probation officer, going to stay with him right outside the door. Yes, ma'am. You want to say something?
Yes, ma'am. They told him once a year. It was a mistake. He didn't know.
According to the complaint, he knew, and I'm just saying what the complaint says. The complaint says that he's required to register 2 times per year, his birth month and 6 months following his birth month. So he registered in December. And so his next birth month would be June of 25. Now, it does not say whether he registered in June of 24. I'm not sure when he became a sex offender, but regardless, he's on bond, he's on probation. So what I'm going to do is I'm not going to revoke his bond, Mr. McDaniel. I want to give the state time to present that issue to Judge Garcia and let Judge Garcia address that. And I'm going to hold him 10 days on the VOP. Ma'am, just a second. I'll give you another chance to talk again in just a moment. So you've got no bond for 10 days. We'll see if Judge Garcia revokes that bond or not. That's her call. If she does, you're going to be there a lot longer than 10 days. But I'm going to hold you 10 days, ask Mr. Mitchell to notify probation. And if y'all want to file a motion for bond reduction, that's up to y'all, Mr. Mitchell. And we'll let Judge Garcia deal with it based upon the complaint. And it is very recent. Today is the 8th, and he was supposed to register in June, allegedly, which would mean he's 8 days late, 7 days late when he was arrested yesterday. Ma'am, you want to say something else?
Also, he was trying to do that 2 weeks ago, but the lady, she was in a meeting. He went to register his car. So he went up there when he was told to.
So he actually physically went to the sheriff's department? Do you do it at the sheriff's department, or do you do it at, because you said something about registering a car?
Yes, sir. He did that while he was trying to do that.
But the car is a totally different part of the city you go to, right?
He told him to come there at the same time to register the car. And he did that.
Ma'am, I'm getting confused. You register your car at the courthouse, you register as a sex offender at the sheriff's department, which is a couple of miles away. So you're saying he went to the sheriff's department to try to register, and the person to do it wasn't there?
She was in a meeting.
Ma'am, listen to my question. Did he physically go to the sheriff's department?
Yes, he did.
How do you know that? Were you with him?
Yes, he was.
Okay, y'all physically went to the sheriff's department, and the person to register him wasn't there?
She was there. She was in a meeting.
Okay, she was in a meeting, but she couldn't do it, so he tried.
Yes, sir.
When was that?
It was 2 weeks ago on a Tuesday. Whenever he was going to go register, it was on a Tuesday.
So here's my question. I was understanding you to say that he didn't realize he had to register twice a year, but now you're saying he tried to register 2 weeks ago.
When he went up there, he like I said, he thought that he had to register once a year.
Okay.
But then when he went up there, his probation officer had told him, that's why he went up there again to try to do it. But Miss, whatever her name is, she was in a meeting.
Okay, so here's what I'm going to do. I'm going to just see you tomorrow. Instead of holding you 10 days, I'm going to ask Mr. Mitchell to look into that claim that he tried. If he tried and she was in a meeting, then I'm a lot more likely to not hold him the 10 days and let everything just take its course. Mr. Mitchell, if you can attempt to verify that, or Mr. McDaniel, you may be able to make a phone call, but you may want to talk to this young lady here before she leaves. So you're welcome to come back tomorrow if you wish. I'll see him again tomorrow, ma'am. Please don't bring a child tomorrow, a young child at least. And Mr. McGriff, I'm going to see you tomorrow and see if we get any more information at that time. Do you have any questions, Mr. McGriff?
No, sir, I don't.
Ma'am, do you have any questions? Thank you for coming. We have Joseph Deese next. Here's your stuff from yesterday, Don. Mr. Deese, good morning. Mr. Deese, you're here for first appearance. Thank you, Mr. Goodson.
Yes, sir.
You're here because you've been charged of violation of state probation. Mr. Deese, this is a warrantless arrest. I have received a text, Mr. Deese, Mr. McDaniel, and Mr. Mitchell from Captain Pelfrey at the Sheriff's Department saying that he anticipates new charges coming this week of armed burglary, grand theft, and criminal mischief.
Armed burglary.
That's what they're saying they're going to be accusing you of. It really doesn't matter for my purposes this morning because I'm going to hold you 10 days anyway, which is what I do on a violation of probation. So if they have the new charges within the 10 days, we'll address them and see if there's probable cause. But for today's purposes, I'm holding you because you've been accused of violating terms of your probation based upon some items allegedly found during a traffic stop. So you've got no bond for 10 days, Mr. Deese. I'm going to see you in 10 days, and we're going to see if they have filed an affidavit. The judge that signs that warrant will be the one to decide if there's a bond or not. If they haven't filed an affidavit, and if they don't have new charges, you're going to be released likely. But let's give them 10 days and see what happens. And I did not write down that case number he's on probation for, but it is Jackson County, Mr. Mitchell. Mr. Deese, do you have any questions?
No, sir.
All right, sir. Have a good day. Hey, Corporal, let's get a urinalysis on Mr. Deese after first appearance, please, since he's on probation, sir, and let us know the results, please.
Yes, Your Honor.
Thank you. And Corporal, is that it for Jackson County?
Yes, Your Honor, it is.
Great. We still do not have Calhoun County connected, so we'll have to jump over to Washington County. Madam Jailer, can you see and hear us in Washington County?
Yes, sir.
Great. First case in Washington County is Daniel Mullins. Mullins, good morning, Mr. Mullins. You're here for first appearance because your bond has been revoked. I watched the video because it wasn't real clear on what happened, but it appears that it was the results of your analysis yesterday in court. Judge Register revoked your bond. So, Mr. Mullins, you've got no bond at this point. You're going to be held until you can get back to circuit court and get this allegation against you resolved. Mr. Mullins, do you have any questions?
No, sir.
Have a good day, sir. Derek Brown. Mr. Brown, good morning, Mr. Brown. You're here on a child support matter, Mr. Brown. The jail provided me a copy of a child support order, an order of contempt, which is dated January the 24th, which is what you're in jail for. But then I've learned since first appearance that order of contempt has been set aside. So the order was signed by the judge in January, and then it was set aside. Mr. McDaniel, help me out. It was set aside in what month? May. But then my understanding from communicating with the hearing officer today is they anticipate a new pickup order being signed this morning in the same case number. For what it appears, and this is a lot of guesswork on my behalf, is that there was a warrant signed because you were behind at some point. You brought it current and you made some payments. They set aside the warrant, and then since then you've gotten behind again. So I have an email from the child support hearing officer stating that she anticipates another warrant to be signed this morning, another pickup order, and she'll be seeing you on that case within the next 24 hours. Mr. McDaniel, is all of that your understanding also?
Correct. And just to give a little bit more clarification, there was two cases, 22-178, 22-179. I think the sheriff's office maybe picked up on 22-179 and didn't clear out 22-178. That's why it got picked up. But Judge Register signed an order back in May that said he had to make a $1,000 payment on each case by July 7th, or the writ would be issued, or he had to make some kind of payment. I think it was $200 payment or a $1,000 writ on each case would be issued on July 7th yesterday. I plan on, it's going to be sent over to the judge today. I don't want Mr. Brown to have to sit in jail any longer than he has to. Mr. Brown, are you able to pay that $2,000 purge?
No, sir. I've been incarcerated for the last 30 days. That's why I was not able to make a payment when I got out in May. 3 weeks later, I ended up getting locked up. That's why I was not able to make a payment. And I got probation on a different charge yesterday, but I never got released because of the child support warrant.
Ms. Donipro will see you tomorrow then, and she'll discuss, the hearing officer, she'll discuss it with you.
Yes,
So,
sir.
Madam Jailer, what we need to do in this case is, I legally can't hold him because he's arrested on the case that the warrant has been set aside. However, the hearing officer advised me they anticipate a warrant being issued this morning. So what I need the jail to do is start the process of releasing him and follow up with the hearing officer, Ms. Donna Fro's office. And I believe a warrant has to be signed not only by the hearing officer, but also by a circuit or a judge, a circuit or county judge. So I think they're going to have the warrant process before you're processed out, Mr. Brown. But I'm not telling the jail to hold you illegally. I'm telling the jail to start the process of releasing you. But I expect that warrant to be signed before they even get you out of jail. So that's where things stand. So, Mr. Brown, if they get it processed, then you're going to see the hearing officer tomorrow on a 48-hour hearing. If they don't get it processed, Mr. Brown, you're going to be released today. Mr. Brown, this morning. Mr. Brown, do you have any questions?
No, sir.
Have a good day, sir. We have Jessica Parrott.
Yes, sir. Yes, sir.
Ms. Parrott, good morning. Ms. Parrott, you're here because you have some charges out of Holmes County. It looks like you're accused of one count of burglary of a dwelling or structure. It says dwelling, structure, or conveyance. That's unusual because those are different crimes. So let me see if I can look at that and clarify that. Dwelling is a different degree crime than structure or conveyance, so it can't be all three.
No,
the
sir.
warrant itself, which I'm looking at now, says that's possession of weapon by a convicted felon, illegal and stolen property, grand theft of a firearm. It does say burglary of a dwelling, structure, or conveyance. When you read the fine print, it says residence, which would be dwelling. So the heading, I guess, is they're using the statute heading, which lists all the types of burglaries. But in the body of it, they are accusing you of a specific subsection, which would be burglary of a dwelling. Regardless, Ms. Parrott, there's no bond on the warrant. What that means is you're going to be held until you can get to Holmes County. When you get to Holmes County, which could be as early as today, it could be the next couple of days, but when you get to Holmes County, you go to another first appearance, and that judge will decide if you're entitled to a bond or not. But there's no bond on the warrant right now. Ms. Parrott, do you have any questions?
Yes, sir.
Have a good day, ma'am. James Golden.
Yes.
Mr. Golden, good morning. Mr. Golden, you're here for a warrant out of Franklin County. It appears to be for the charge of grand theft. Mr. Golden, the jail didn't have a copy. They didn't receive from Franklin County a copy of the warrant. So I went on the statewide system this morning and found the warrant and printed it out. There's no bond on the warrant. It's a hold without bond, allegedly for a failure to appear. The warrant I've got in front of me is dated February of 2023. So what that means, Mr. Golden, is you're going to be held for Franklin County. They're going to pick you up. When you get picked up, you'll go back to Franklin County or go over there at least. You'll go before a judge, and that judge will have another first appearance and may or may not modify the bond. But right now, you've got no bond out of Franklin. Any questions, Mr. Golden?
No, sir. I just want to state for the court, I've been locked up for the last 30 months in DOC. So Holmes County is where I've been.
Holmes County Prison? Okay, so here's the question. Here's the question then. Madam Jailer, do y'all have any documentation showing that he came from the prison?
We picked him up on our charges from the prison. He did EOS from prison.
He had some charges. You picked him up for these charges here or for your local charges?
You know, for charges in our county, and he took care of them yesterday. So when we ran him, he had this, so he would use it.
So what I'm going to ask you to do is when you send him to Franklin County, please send him with the documentation that you got him from the Department of Corrections. The reason that's important, Mr. Golden, is when you get over there, you show that documentation to your first appearance attorney. The judge needs to know that because it may not be a real failure to appear. It may be something that they need to set a bond on or release you on some conditions. That'll be that judge's call, but it doesn't appear that it's it may not be a real failure to appear. Okay.
Yes, sir.
Have a good day, sir.
Thank you.
Madam Jailer, anything else in Washington or in Washington County?
No, sir.
Thank you, ma'am. Lastly, we have Calhoun connected now. And let me get back to my Calhoun County stuff. Mr. or Madam Jailer, can you see and hear us in Calhoun County?
Yes, sir.
Great. Calhoun County, I believe, only had 2 cases. First is Charles DeFada. Mr. DeFada, the jailer's going to show you where to stand at. Sir, you're here because you're accused of one count of resisting an officer without violence. Mr. DeFada, there is probable cause in the complaint. I looked at your criminal history. You have several charges, but most of them are really old and they're not significantly violent, Mr. DeFada. So let me ask you a couple of questions. Where do you live at, sir?
With my girlfriend, I'm Alpha now.
Okay. And do you have a job? Are you employed?
Yes, sir. Yes, sir.
Where do you work at?
Jerry Pivus Electric in Panama City.
How long have you worked there?
Since 2016.
Have you ever been charged with a crime outside of the state of Florida?
No, sir, I have not.
So I've got your Florida history, but I know nothing about out of state. But you don't have anything out of state, Mr. DeFada?
No, sir.
All right. Let me listen to the state in defense, and I'll make a decision on bond or release status. Mr. Mitchell, anything?
No, Your Honor.
Mr. McDaniel?
No, Your Honor.
Mr. DeFada, I'm going to let you pick between the bond and the conditional release. As I said, your criminal history is, it looks like it's been several years since you've been charged with a crime based upon what I've been provided. So if you want to choose the bond, it's $2,500. If you'd like to accept the conditional release, I'm going to offer you a conditional release. If you do accept the conditional release, you would have the standard conditions of every release, Mr. DeFada. Do you understand the choice between the bond and the release, or do you want me to explain it further?
What's the conditional release? What's the conditional release?
Conditional release, so you know how a bond works, I'm assuming, but a conditional release is a little different. A conditional release doesn't cost you any money to get out of jail, but there's a trade-off. The trade-off is on a conditional release, you have more rules to follow than a bond has. So bond costs you money and you have fewer rules to follow, but on a conditional release, you have more rules to follow. You've got to check in with a conditional release officer once a week. Usually it's by phone. You've got to pay a cost of supervision, but it's usually cheaper than a bond. Usually the cost of supervision is around $30 to $50 a month. So it's just a monthly cost instead of going through a bondsman. But you've got to check in. You got to stay out of trouble. They can drug test you. You can't use alcohol. So those are some of the conditions of the release. So some people say, I'd rather post a bond, have to put up some money, but have fewer rules to live by and not have to answer to an officer while I'm out. Other people say, I'd rather take the conditional release, stay out of trouble, follow the rules I'm given. It's almost like probation while the case is pending. So you can let the jail know whether you want to choose the bond or the conditional release after first appearance, and they'll either let you make the phone call for the bond or let you accept the conditional release. If you accept the conditional release, you'll have to meet with a conditional release officer somewhere today, probably right across the road at the courthouse. It's probably where they're going to send you to meet with a conditional release officer. So you can make that decision after first appearance. Do you have any other questions you want to ask me about it?
No, sir, that's it.
All right. Wish you the best, sir. Anthony Brown. Mr. Brown,
yes, sir. Good morning,
you're here because, good morning. Mr. Brown, you've been accused of violating terms of your probation. The warrant I looked at this morning in your case has a bond already on the warrant. The judge put a cash bond in your case of $782. It appears your violation was based primarily or perhaps solely on financial issues. So you've got a cash bond of $782. If you post that cash bond, you'll be released. Mr. Brown, if you're not able to post a bond, then what will happen is the public defender's office will see you at the jail in Calhoun County. Mr. Brown, do you have any questions?
Yes, sir, I do. Well, this is a fairly old case back before December, sir. They let me out on 6 months probation. Well, I violated that with a new charge, which is a felony battery. I had 52 days originally on this charge, and then when I violated this time on a felony battery, I got 42 days. However, I'm looking to go to a probation hearing tomorrow for a felony case. Well, those 2 cases were running together. That's why it was so high, $700 some odd dollars, but the original bond was like $250. And it's just, if you look in the record, it's like 2 cases running together. And when I went to the felony hearing, that is if they couldn't find that it's misdemeanor case. However, it was like lingering out in a limbo somewhere. And I told the judge in the felony case, he was like, well, if it come up, we'll deal with it later. But at the time, they let me go on felony probation and we weren't able to find it. But then when I got arrested this time, it just popped up with a warrant. So I'm trying to figure out why. You know what I'm saying? As of today, I have 94 days in.
Yeah, Mr. Brown, whether or not you're entitled to credit for the time you were serving on the felony is not necessarily an easy question to answer. You're not necessarily entitled to credit for that. You may be, you may not be. It can be fairly complicated. The bottom line is, I'm not going to release you on another judge's warrant based upon a very limited amount of information. What I am going to do is I'm going to ask Mr. McDaniel to notify his counterpart in Calhoun County. I believe that would be Ms. Parrish. Mr. McDaniel, please notify Ms. Parrish, the Assistant Public Defender in Calhoun County, and let her know that Mr. Brown is in jail with no bond. If Ms. Parrish determines her review, or she comes and sees you, one or the other, that you shouldn't be there, then she'll bring that up to the judge's attention immediately. Either Judge Young or Judge Grover in Calhoun County, but I'm not going to get involved in their case, given the limited amount of information I know. I just don't know enough about it. I'm not comfortable imposing myself in their case. Okay.
Yes, sir, because I mentioned something about it to the judge, and he was like, he didn't see it nowhere in the record. I don't understand how was that possible when it was a Calhoun County case.
There's no way I can answer that. I don't know how he couldn't find it. I don't know if it was there. I have no idea. But Ms. Parrish should be out there to see you in the very near future, sir.
All right, thank you, sir.
Thank you. Anything else in Calhoun County?
No, sir, that's it.
Thank you. Have a good day.
Thank you. Yes, sir, you too.
Mr. McDaniel, anything else from the Public Defender's Office?
No, Your Honor.
All right, looks like they've wrapped up there. Let's go back to Texas and Judge Stevens. Or not, because Judge Stevens has muted himself, which he sometimes does. He forgets that he hits the mute button and then doesn't unmute. Let's go to McNally.
I know, time's flying, isn't it?
Yeah,
Huh? You actually graduated, what, in 73?
I did graduate. I joined the service in 73.
Okay. Well, good to see you.
Good to see you.
Can you pay that today, or you need time?
Yes.
All right. Take care of yourself.
All right, you
Thanks,
also.
thanks a lot.
Thank you.
All right, can I have Zachary Richard Williams, 25B147-804A. Could I have Tamia Henderson over at the table here? And Gary Jackson. At least I'm trying to do these, separate some of these with probation cases, so you guys don't have 400 people down there. Your name, sir?
Zachary Williamson.
All right. Wow, 5 counts. Failure to submit the weekly testing is ordered on June 6th. They say you showed for testing, were unable to submit a sample 3 times, attempted. June 9th, same thing. Failed to submit a sample, attempted 3 times. June 19th, attempted 2 times. Didn't submit a sample. June 21. What? Attempted 1 time. Didn't submit a sample. June 24, attempted 1 time. 5 counts. Plead guilty, your probation could be revoked. These all arise out of a separate event, transaction, or occurrence, so you could have your probation revoked, and you could be incarcerated for 93 days. Do you understand that, sir?
Yes.
Did you sign the advice of rights and read and understand the rights?
Yes.
If you plead guilty, you'll be giving up all those rights. There will be no hearing or trial. Do you understand that?
Yes.
You have the right to a lawyer. I'll be happy to give you one at public expense. Do you understand that?
Yes.
Would you like a lawyer?
No, thank you.
Are you sure?
Yes.
All right. I'll enter a not guilty. Well, first of all, I'm going to ask you how you plead. I'm going to need Beth in here. To the charge, you failed to submit submit the weekly testing as ordered on June 6, 25. Failed to submit a sample. How do you plead?
Not guilty.
All right, we're just going to have a hearing. I'm going to enter a not guilty plea. We need Beth in here. And so I'm going to enter a not guilty plea on all 5 counts. And then we'll have the hearing and we'll go from there. Okay? Any questions?
What will this hearing be?
Right today, in about 5 minutes. You can have a seat. Thank you. Darnell Lorenzo White. Darnell Lorenzo White. Who's this? What are they doing here? Where's Darnell White? Is Darnell White here?
Yep, I'm bringing him in right now, Judge. It's a Judge Hessen case.
Mr. White, your name? I can't hear you, sir.
Darnell White.
Mr. Burgess, your appearance?
Good morning, Your Honor. May it please this honorable court, David Burgess, on behalf of Darnell White, both of us appearing via Zoom.
All right, so you need an adjournment, right?
Yes, Your Honor, we just received the digital discovery this morning, and I just need to review with my client. 1 week would be sufficient.
Mr. White, you have the right to a probable cause conference within 14 days of the date of the arraignment. If I grant that request to adjourn the case, that means the probable cause conference will not take place within 14 days of the date of the arraignment. Do you understand that?
Yes.
Your lawyer needs additional time to prepare. You understand that? And he's asking me to adjourn the case.
Yes.
Do you wish to waive your right to have the probable cause conference within 14 days?
Yeah.
Not to interrupt the hearing, but Barbara, I know you're on your way out, and I wanted to say thank you for the 5. Appreciate that a lot, and we love you too. So have a good day.
All kinds of different dates on here. They had July 9th and 15th or something, it looks like. So we're going to do it July 15th and 22, Lisa or Heather, is that right?
If he just wants a week, we can do July 15th at 10 o'clock.
Yeah, I know, but I'm going to set it for exam too. July 22nd, the exam will be at what?
We can do the 22nd at 11:30.
Okay, so that's what I'll set, Mr. Burgess. You're going to have the July 15th at 10 will be the probable cause conference. July 22 at 11:30 will be the exam. Let me just double check something here.
Yeah. And
It looks like bond was set. Was this an out county magistrate or what, Mr. Burgess? Do you know that set all this?
Yes, Your Honor, I believe it was an out county magistrate. I did not appear for the arraignment. I know it was released over a weekend.
Okay, so I'm going to go ahead and continue the bond. He showed up. Bond is continued, and we'll see you back here July 15th, sir. Any questions?
No, Your Honor.
Anything else,
No,
Mr.
Your Honor.
Burgess? Have a good day. Thank you, gentlemen.
No, Judge,
All
thank you.
All right, let's head over to San Antonio, Bexar County, and we'll say good morning to Judge Boyd.
Good morning. Are y'all ready to?
Yes, sir.
Are y'all ready to proceed on the motion to revoke?
Yes, sir.
Okay. The court is calling 2024 CR 008354 State versus Jose Elias Gamboa III. Could I have parties announced?
Duffy Pitlock for the state of Texas, Your Honor.
Teresa Conley for Mr. Gamboa. And are you Mr. Gamboa?
Yes, sir.
All right, did you review the motion to revoke community supervision with your attorney? Did you understand it?
Yes, sir.
Yes.
Before you move further, I have notes from the last court visit. Sally pled true, and this was to get the results of a tally.
So you pled true on June 17th with Judge Angelini to 38 and 38?
Yes.
All right, thank you. And all right. Then Judge Angelini previously found violations of 38 and 38 true. And then there was a request for a TAP evaluation?
Yes, Judge.
All right. And what is the recommendation state?
Yes, Judge. It is in line with probation's recommendation after the TAP eval. That is to amend for local ISF Roman numeral 2, followed by ISP. We're asking for defendant to wait in jail for placement. upon release, outpatient treatment through the Veterans Administration, and may include the BCCSCD dual diagnosis outpatient program at the client's expense, monthly urinalysis, and documented sober support meetings, Judge.
All right, Mr. Gamboa. Right, on this case, the minimum sentence you can receive, the maximum sentence you can receive based upon your plea bargain agreement is 2 years. So if you want, I can follow everybody's recommendation. It would really help you. Or if you want, I can revoke you and sentence you to 2 years.
Now, I was gonna ask you, man, am I gonna get released? And does that mean, because he said the VA, and do I get to go to the VA for my assistance, or how does that work?
No, what ends up happening is based upon their recommendation, you're going to be in custody and you're going to get transferred to an inpatient treatment facility. Then once that is completed, then you will have the VA.
Now, the inpatient, what is it called? It's
They're asking for local ISF.
yes, Judge.
It's local ISF.
And how much time do I have left on probation?
Oh, your probation time on these type of cases, your probation can be extended up to 10 years. I mean, total.
So right now, because I already have over a year.
Well, I mean, here's the thing. Legally, I must give you credit for any time that you've been in custody. It's completely up to you. If you want me to revoke you, I'll revoke you. I will sentence you to 2 years. What will end up happening is they'll check how much time you have credit. They will let you know how much time you have credited. They will give you credit for any time that you spent in custody on this case.
Because there's also a wait, right, for this program?
Yes, there is.
Yeah, because I'd rather just.
No, here's the thing. How old are you?
I'm 45. Man.
All right, so you can make these decisions. These are your two choices. I can revoke you. What I'm telling you is based upon your plea bargain agreement, the most I can sentence you to is 2 years in the prison.
Okay.
You will do 2 years at the prison. Sometimes because it's the prison, if you have enough time, sometimes they will parole you from the Bexar County Jail. Then other times they will not parole you from the Bexar County Jail. I'm not in charge of that system,
Okay.
but at the most, you will do 2 years.
Okay, this one.
Yeah. Okay.
This one. I'd rather do 2 years.
All right. Can you raise your right hand for me, please?
Sure.
Do you solemnly swear or affirm the testimony you give will be the truth and nothing but the truth, so help you God?
Yes, ma'am.
All right, you can lower your hand, state your name for the record.
Jose Elias Gamboa III.
All right, Mr. Gamboa. Probation is recommending that you be continued and that you go into inpatient treatment. Are you telling the court that you do not wish to follow that recommendation?
Yes, ma'am.
And are you telling the court that you wish to be revoked and given the 2-year sentence?
Yes, ma'am.
Are you waiving your right to appeal?
Yes, ma'am.
All right, then you were previously found to violate conditions 38 and 38. The court is going to grant the motion, revoke, sentence you to 2 years in the prison, give you credit for any time served. And I'll request the therapeutic community. The therapeutic community does not increase the time that you're at the prison, but it is to help you with any type of sobriety issues you have or drug issues you may have. I'm going to show you what's entitled Trial Court Certification of Defendant's Rights to Appeal. Here, sir. Thank you. Did you review that document with your attorney? Did you understand it and sign it?
Yes, ma'am.
All right, because this is a plea bargain agreement, because I followed your plea bargain agreement and because you waived your right to appeal, you do not have the court's permission to appeal. Because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. If you have a question over what a weapon or ammunition is, you'll need to speak to an attorney. Do you understand?
Yes, ma'am.
All right, good luck to you, sir. We can go off the record. When you're released from custody, if you can't find a place that can help you, you can always come back to court. If I'm here, I'll make sure they find a place for you, okay?
Yes, ma'am. Thank you.
Good luck to you.
Thank you, Your Honor.
You're welcome.
Excuse?
Yes.
Bailey, you just asked the question in the chat. I wonder if he could have gone to Veterans Court. I just pulled up Bexar County Veterans Treatment Court, and they serve veterans with PTSD, TBI, stuff like that, substance abuse. But, and I'd have to do more research, but one of the things that I just noticed is that it is part of the docket of Court at Law number 6 in Bexar County, and the courts at law are misdemeanor courts where she's a felony court. So that. But yeah, I'd have to do more research, but I don't know if he would qualify based on that alone. Let's go. Well, let's stay here. Let's see who's coming up.
All right, so did you receive an offer?
Yes, we did.
All right, and do you have all discovery?
I believe I do. Yes, Your Honor, to the best of my review.
All right, if y'all could do an acknowledgement of discovery for me, please.
I will.
All right, and Miss, how old are you?
34.
All right. Miss Ferguson, I need a 3-week reset for a plea deadline date, please. The dates you're going to receive, that's the date. You need to let the court know if you've reached an agreement. If you have not reached an agreement, your next court date will be your jury trial date. All right, July 29th. Once you sign the reset form, you are excused.
Okay, let's go ahead and go over to Judge West.
Good morning. Are you Tiffany English?
Yes, ma'am.
And Mr. Rojas, will your client waive the formal reading of the motion in each case?
She will, Your Honor.
Ms. English, in 18-30705, I have a motion to revoke your unadjudicated probation. Shows that you were placed on probation June 10th of 2019 for the offense of assault on a peace officer, a second-degree felony, and that was a 7-year deferred probation. Is that correct?
Yes, ma'am.
And in cause number 19-31722, I also have a motion to revoke your unadjudicated probation. Shows that you were placed on probation June 10th of 2019 for the state jail felony offense of possession of a controlled substance, and that was a 5-year deferred probation. Is that correct?
Yes, ma'am.
And Judge, I just want to clarify for the court's knowledge, I spoke with Ms. Cole. That was extended. When I first looked at it, it looked like it was
Okay.
2019, and now it's 25, that it would have been expired, but I confirmed
That it had.
been extended.
Okay, thank you. Each of these cases allege that you violated your probation. Count 1 in each case alleges that you tested positive on a drug patch for tetrahydrocannabinol and cocaine May 8th of 2025. And is that true or not true?
Yes, ma'am.
True or not?
Sure.
Count 2 in each case alleges that you failed to provide verification of completing a job search. And is that true or not true?
Yes, true.
Count 3 in each case alleges that you are behind in your court-assessed fees. Is that true or not true?
Sure.
Count 4 in each case alleges that you failed to successfully complete the SafeP program. Is that true or not true?
True.
Did you enter your pleas of true to counts 1 through 4 freely and voluntarily?
Yes, ma'am.
And did you plead true to those counts because they're actually true?
Yes, ma'am.
In each of these cases, I have here on the computer some documents that have your signature on them that the state's marked as exhibit number 1. Before you signed these, did you go over them with Mr. Rojas?
Yes, ma'am.
Do you fully understand them?
Yes, ma'am.
And do you understand if I follow the agreements that you've made with the district attorney, you will be waiving or giving up any right to appeal?
Yes, ma'am.
State tenders number 1 in each case?
No objection.
It's admitted in each case. Is there any evidence that Ms. English is not competent?
No, Your Honor.
All right, ma'am, in each of your cases, I'm going to find that you entered your pleas of true to counts 1 through 4 freely and voluntarily. Find those counts true. In cause number 18-30705, find sufficient evidence to find you guilty, and at this time find you guilty of assault on a peace officer. Sentence you in accordance with your plea agreement to a term of 3 years in the institutional division of the Texas Department of Corrections. You will receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive.
Yes, ma'am.
In cause number 19-31722, also find sufficient evidence to find you guilty, and at this time find you guilty of possession of a controlled substance. sentence you in accordance with your agreement to a term of 18 months in the state jail prison. You will also receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. These two cases will run concurrently, which means together at the same time. I'm handing you the trial court certifications in each of your cases that shows these were agreements that I followed, so you have waived your right to appeal. I have also handed you a written admonishment regarding your ineligibility to possess a firearm or ammunition. Because of the judgments entered against you, you're ineligible under Texas law to possess a firearm or ammunition. Possession of a firearm or ammunition could lead to charges against you. Firearm is a legal term, and you should read that written admonishment I provide you to see what devices qualify as a firearm. If you have questions about the laws that make you ineligible to possess a firearm or ammunition, or about how long that lasts, you can talk to Mr. Rojas.
Yes, ma'am.
Good luck to you, ma'am. You can go back with the bailiff.
Thank you.
Shelton Reddick, Mr. Rojas. We're going on count one only.
Yeah.
Good morning, sir. Are you Shelton Reddick? And will your client waive the formal reading of the indictment?
Here we are.
Mr. Reddick, in cause number 250050, the state has elected to proceed on count one only. It alleges that you committed the state jail felony offense of unauthorized use of a vehicle from October 14th of 2024. And how do you plead to that charge? Are you pleading guilty freely and voluntarily? And are you pleading guilty because you actually did what they've charged you with? I have here on the computer some documents that have your signature on them that the state has marked as exhibit number 1. Before you signed these, did you go over them with Mr. Rojas? And do you fully understand them? And do you understand, if I follow the agreement that you've made with the district attorney, that you'll be waiving or giving up any right to appeal? Also, do you understand, if you're not a U.S. citizen, that a plea of guilty or no contest may result in your deportation, exclusion from admission to the country, or denial of naturalization under federal law? State tenders number 1.
No objection.
It's admitted. Is there any evidence that Mr. Reddick is not competent?
No, Your Honor.
All right, sir, I'm going to find that you entered your plea of guilty freely and voluntarily. Find that you're mentally competent and you understand the nature and the consequences of your plea. Find sufficient evidence to find you guilty, and at this time find you guilty of the state jail felony offense of unauthorized use of a vehicle. Sentence you in accordance with your agreement to a term of 15 months in the state jail prison. You will receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. I'm handing you the trial court certification that shows this was an agreement that I followed, and so you have waived your right to appeal. You've also been handed a written admonishment regarding your ineligibility to possess a firearm or ammunition. Because of the judgment entered against you, you're ineligible under Texas law to possess a firearm or ammunition. Possession of a firearm or ammunition could lead to charges against you. Firearm is a legal term, and you should read that written admonishment I provide you to see what devices qualify as a firearm. If you have questions about the laws that make you ineligible to possess a firearm or ammunition, or about how long that lasts, you can talk to Mr. Rojas. All right, good luck to you, sir. You can go back with the bailiff. See, Carrington Scott, Mr. Rojas. Good morning, sir. Are you Carrington Scott? Mr. Scott, in cause number 250538, you're charged with the second-degree felony offense of robbery from March 20th of 2025. And what that means is that if you go to trial and you're found guilty, the range of punishment is between 2 years and up to 20 years in prison. Do you understand? And I have here,
Actually, there's some priors that are not listed in the indictment.
okay,
I think his actual range is habitual.
okay, and you've gone over that with them, and as notice either has or will be filed of
Notice
those?
will be filed. We'll give oral notice on the record today that we will file notice with intent to enhance his punishment based on his prior convictions. We will get that in writing and get that filed this week.
And there's at least 2 prior non-state jail sequenced?
Non-state jails.
Okay, so Mr. Scott, if those prior convictions are true, what that means is that if you go to trial and you're found guilty, the range of punishment becomes that of a habitual offender, which is a minimum 25 years in prison up to 99 years or life. Do you understand? I have here on the computer a plea bargain rejection that has your signature on it with Mr. Rojas's that shows that the district attorney's office has made an offer if you wanted to enter a plea of guilty. And that would be to go, I guess, on count 1 only, and for a 15-year term in the institutional division of the Texas Department of Corrections. That would be to go on the robbery itself without those enhancements for a 15-year sentence. You have every right to reject that and have your case set for trial. I want to make sure you understand what your possible consequences are and what your options are. You understand all of that.
I understand the court.
And you want to reject that offer and have your case set for trial.
Yes, ma'am.
All right, we'll get that done. Mr. Scott, Mr. Rojas has been appointed to represent you. He's one of the attorneys who handles a lot of cases for me as a court-appointed attorney. With your permission, I can release him and appoint another attorney today who could begin preparation for trial a little quicker. Is that okay with you? All right, Mr. Rojas, you are released. Mr. Scott, we will appoint someone today. They should be out to see you very soon to begin preparation for trial. Terry Thompson, 2 cases, Mr. Rojas. Good morning, sir. Good morning, sir. Are you Terry Thompson?
Yes, ma'am.
And Mr. Rojas, will your client waive the formal reading of the indictment?
He will, Your Honor.
Mr. Thompson, in cause number 250474, you're charged with the 3rd-degree felony offense of false statement regarding property or credit, and that's from March 13th of 2025. And how do you plead to that charge?
Guilty.
Are you pleading guilty freely and voluntarily?
Yes, ma'am.
And are you pleading guilty because you actually did what they've charged you with?
Yes, ma'am.
I have here on the computer some documents that have your signature on them that the state has marked as exhibit number 1. Before you signed these, did you go over them with Mr. Rojas?
Yes, ma'am.
Do you fully understand them?
I do.
And do you understand, if I follow the agreement that you've made with the district attorney, that you'll be waiving or giving up any right to appeal?
Yes, ma'am.
State tenders number 1.
No objection.
It's admitted. Is there any evidence that Mr. Thompson is not competent?
No, Your Honor.
All right, sir, I'm going to find that you entered your plea of guilty freely and voluntarily, find that you're mentally competent and you understand the nature and the consequences of your plea, find sufficient evidence to find you guilty, and at this time find you guilty of making a false statement regarding property or credit, sentence you in accordance with your agreement to a term of 3 years in the institutional division of the Texas Department of Corrections. You will receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. I didn't go over this as well. Are you a U.S. citizen?
Yes, ma'am.
Okay. I'm required to ask. So I will also sign a dismissal as part of this plea agreement in cause number 250475. I'm handing you the trial court certification that shows this was an agreement that I followed, and so you've waived your right to appeal. I have also handed you a written admonishment regarding your ineligibility to possess a firearm or ammunition. Because of the judgment entered against you, you're ineligible under Texas law to possess a firearm or ammunition. Possession of a firearm or ammunition could lead to charges against you. Firearm is a legal term, and you should read the written admonishment I provide you to see what devices qualify as a firearm. If you have questions about the laws that make you ineligible to possess a firearm or ammunition, or about how long that lasts, you can talk to Mr. Rojas. All right, good luck to you, sir. Thank you, sir. Let's see, what are y'all doing on Gabriel Smith? Did you do a rejection?
Judge, if I may, I'm inclined to re-indict that to assault on public servant. Maybe just reset it, let me do that, and then reset it for one last review.
Sure.
I don't know that.
All right, well, they sort out what they're going to do next. Let's go back to Judge Boyd.
Okay. All right. So, family violence, if I can see you all in criminal trial division. Yes.
Never mind, I give her a chance and she goes away. Let's do one of Michael's favorite things. Let's go to Louisiana, where I believe they're going to do a parole hearing, perhaps.
Okay, thank you.
Good morning.
Good morning, Mr. Green. How are you doing today?
I'm okay, And yourself?
I'm doing good, doing good. All right, Mr. Green, you are here to deal with a revocation hearing, is that correct?
Yes, sir.
And what is your DOC number?
532484.
Okay. Do you have a waiver in front of you, a piece of paper that shows that's exactly it? And did you sign that?
No, sir. At the time, I didn't. It's
okay. Would you read over? So you didn't sign that?
No, it just said refusal to sign, but I never was showed this.
Okay. Have you read that?
Just now went over it a little bit. Yeah, it's talking about it's asking me questions.
Yes, sir.
It's asking me it's like six questions.
Have you read all of that, and do you agree with all that?
Yes, sir.
Okay. All right. If you've read that and agree with that, and that's your waiver sheet, then we'll get on with the hearing.
As far as me, no, I haven't been medically in the past 5 years. No. Yes, I can read and I can write. You know, do you understand your parole charge against you? Yes, sir. Do you want to speak in your own behalf? Yes, sir. What is your average monthly income at the time? None really now.
Okay, we don't really need to, we don't need to answer that. Let's just go ahead and if you agree with that and you realize that you're not eligible for an attorney and you choose not to hire an attorney, then we need to get on with the hearing. Is that correct?
Yes, sir. Yes, sir.
Okay, well, let's move on with the hearing then. And Mr. Green, your case has been signed to Mr. Tillis. And Mr. Tillis is going to go over the rule violations and ask you about what you plead on those rules, if you're guilty of that, and if you want to make a statement or if you're innocent of that, okay?
Yes, sir.
Good morning, Mr. Green. There are four violations on 4/10/2025. A warrant was for domestic abuse battery was issued for subject out of Orleans Parish. On 2/3/25, a warrant with simple battery was issued out of Jefferson Parish. On 4/16/25, parole parolee was arrested. How do you plead? Guilty or not guilty, or with a statement?
Well, not guilty with a statement for the domestic, because it was a case of me. It was a case of me and
That's good. We're not guilty. We will come back and let you explain about it.
okay.
All right. The next one is on 4/16/25. After subject was instructed to report to probations and parole, and after the parolee was informed about his warrant for simple battery and domestic abuse battery, the parolee stated L. Anderson that he did not choke a formal dating partner. How do you plead to this?
Can you say that again? What was? Can you I couldn't hear you.
Was stated that you choked a formal dating partner.
Well, plead not guilty.
Not guilty with the statement?
With a statement.
Okay, good. And number 10, the violation number 10 is subject is $1,136 in the rear. How do you plead to that?
Let's see, not guilty. Well, I just trying to maintain life, and stuff like that. I couldn't really get to it at the time working and taking care of my little girl. I couldn't really.
Not guilty. You're pleading not guilty?
Not guilty.
Okay. All right, let's go back to the first violation. If you want to elaborate on it, the domestic abuse battery was issued. We didn't let the thing. Do they have a statement? No. This person here wanted to talk to the girlfriend.
Okay, yeah, you want to call on her?
Yeah. We're gonna get back to the statements, Mr. Green, but Ms. Brittany Augustine, your girlfriend, has a statement.
Hey, good morning, Judge. Good morning. I just wanted to say that the situation he's in right now, I feel like me and him have been off and on for over 2 years now. When we was off, whatever he had going on over there, I feel like it's been vindictive. I feel like if he was released today, he would be at work tomorrow. James is one of the sweetest, kindest, caring person I know. I know that if he was released, he would come home and do exactly what y'all expect of him. A lot of people might look at him and see a tough guy. When I look at him, I see a sweet guy. Judge, I have seizures. He helps me with that. He's helped me get over a lot of things as far as alcoholism. He's really, really, really like my rock outside of this world. I don't see him as being a monster. I don't see him as being a bad guy. If he wasn't around me one time, I probably would have died. He is one of the most sweetest guys I know. Even when we took our split apart, he still called to check up on me, still made sure I made it to work when it was hot. I just feel like the accusation against him is a woman being vindictive. He has a daughter that he takes care of. The mother is also incarcerated. So that child her father is all she has, And I know they told me to keep it short, but I really wish that he can be released so he can do the best that he can and pay you all and just move on with his life.
Okay, so you're not the victim that was choked.
He never touched me. Never. That's what I'm explaining to you all. That's not in his character. Even when we fuss, and I'm quite sure you all have wives or girlfriends, and it's a disagreement. Women, I know I'm dramatic. He'll walk away before he do anything.
Okay, thank you so much.
And that's just me speaking on my experience with him. I really wish that he can be released so he can come home.
Okay, thank you so much.
Really, the picture that's being painted of him, and I'm not just saying this because I'm his girlfriend. Like I said, we've been off and on. If that was the case, I would have the same story.
Okay, thank you so much. Thank you so much. Mr. Green, now you want to elaborate on that domestic abuse charge?
Yes, sir. See, the thing is with Paris Turner, like she said, that the girl's really vindictive and she manipulative. Like, you know, we got into 2 altercations to where, all right, I cheated and she cheated. See what I'm saying? But at the end of the day, it's like when I left her, she just like I never knew nothing about no still with all that, none of that. Like they just put like it just came out of nowhere. I never knew nothing about none of that, and I had just left her and I moved on with my life. Like
okay. Go ahead. You had something else to say?
I'm just saying, like, you know, that's not me. Like, you know what I'm saying? That's why I mean it's just crazy. Like I'm just really big to me.
Okay, so did you hit her, choke her, or anything?
No, we had you know, in like as far as like relationships that goes on with different women and stuff like that, and you know, we lived there and we had like I had cheated, like I said, I had cheated on her and she had cheated back, and we had altercation as far as like verbal and stuff like that. At the time, it was getting hot and hectic and stuff like that. But as far as me put my hands on her, no, I never did put my hands on her. So you know, the thing is, by me leaving her. The thing about me leaving her, I got something the thing in my phone that shows that you know but as far as like what she was saying, like she like I said, she very vindictive and very like manipulative. So she already had in her mind that she was gonna see and do all kinds of things and stuff like that.
Okay. All right, thank you. On violation number 7, you were instructed to report to probations and parole. What happened there? You said you pled guilty.
Can you tell me what day it was? That was the 16th.
4/16/25.
Yeah, I was in the office. That's where I got arrested. That's why it was happening. I got arrested from the office. I never ran from nothing. I never knew nothing about no charges or nothing.
Okay.
Now the one thing I did, all right, far as like I had got into it with a coworker. I got into it with one of my coworkers, and we know it was the altercation for me pushing him. He pushing me. I was defending myself. He pushed me. I pushed him back and stuff like that. But as far as anything else, no.
Okay. What about your arrearment? Your $1,136 in the arrear.
I mean, I plan on paying that. I plan on paying that. I just like I said, like job. You know, the job I was working at, it really wasn't paying much, and I got to take care of my little girl, stuff like that. You know, got to pay bills, and by the time I have any kind of money, it's really nothing. So, I mean, that's on me for slipping. You know, everyday life goes on. Everyday life is out there going on, and I try my best. I don't get into trouble or nothing. I stay out the way, and I take care of my family. My mom, she gonna be 60. My mom, she gonna be 60, Mom, she gonna be 60 in October. My little girl just made 17, graduated. You know, that's my mind really been trying to focus on with trying to get my money together and trying to, you know, take care of my family.
I got you. Thank you so much. Thank you so much. Any other questions?
Yeah. I'm sorry, but Mr. Green, what you're saying and what I'm reading in this file is vastly different. In your preliminary hearing, you stated, the parolee stated to L. Anderson that he did choke a former dating partner. You actually had a protective order against you, and they had called and said you were harassing them, and you had a protective order against you.
So see, all right.
And then you also did have the fight, physical altercation, which is prohibited while you're on parole from having physical altercation. Should be every day, but especially on parole. And so those things, and then I read in your preliminary hearing how you gave the officers a tremendous amount of grief, stating, how about if I stand up and pop you because you thought they were smirking, and you refused to sign, and you were argumentative. All of these things lead me to believe that you would be very difficult to supervise on the street.
See, I've been under supervision for 18 months, going on 18 months now. And see, I never had got into no argument or nothing period with the well, this is the thing. This is the thing. The lady, when on the day that I went to the office, they saying that I told them, like, I had kind of gotten into the altercation with the person that I worked with. All right, but if the man who helped arrest me, he could tell you himself personally that I didn't state nothing. I didn't say none of that about me choking nobody, nothing like that. That is false. I really would like for to get a lie to the test on that, because I know I did not state and say that. I did not tell her that. She
Okay, let's read something else. January of 2025, your officer showed up at your place of business and you popped off to him saying, don't come to the restaurant. I don't want people to see you here.
That's not me. I never worked in a restaurant, ma'am. That's not me.
I am looking at files for Mr. Green. Okay.
I work.
Very much, Mr. Green. That's all I had. Thank you.
Yeah, I worked at the Imperial Trading. I don't talk crazy or nothing like that to nobody. I'm trying to just excuse me. Can I tell you something? I've been in jail. I've been incarcerated for almost 20-something years of my life. My last sentence was 12 years. I'm 36 years old. Like, my family's getting older. All I'm trying to do is just take care of my daughter that I left out there by herself, and move on with my life. Like, I don't have no problems with working, and I work all the time. When I first had got released from jail, the 2 weeks after that, I had a job at Imperial Trading. I worked at Imperial Trading for almost a year. I think it was a year. It was a year. I worked at Imperial Trading for a year. I'm not a problem. I'm not a problem.
Let's stop. Let me stop you there just a second. You seem to be a problem. You've been on parole for 18 months. In that length of time, you've had a protective order against you, 2 simple battery warrants for different people, and you've had 11 traffic attachments that were on your NCIC record. You can't tell. Wait, don't interrupt me. And plus, your attitude with your parole and probation officer at the hearing and not refusing to sign, it sounds like you are a problem to me, and that's why I have a problem. You justifying everything and kind of sugarcoating it, saying everything's fine, but the truth of the matter, it isn't fine.
Sir.
You got any questions?
I have no.
Okay. All right. Are you ready to vote? Okay. Mr. Tillison?
My vote is to deny because of the violations of parole.
Revote.
Revoke.
Okay.
I vote to revoke parole based on non-compliance with parole condition.
Okay. And I also vote the same way to revoke you, violations of Rule 4, 7, 10. So your parole has been revoked. It's 10:04 in the morning, and that's the end of the hearing.
Denied. Well, he was charming, wasn't he? He's peaceful, he's nice, he's calm, he's all these things when he's choking somebody or when he's in chains. Any other time, it appears that he's a bit of a nightmare. Such is life. Let's go back to Judge West. FYI, unlike Judge West, where we're waiting for sound, hopefully we get that in a moment, that sound comes courtesy of Michael Groff. So, Michael, thank you for that. Wonderful sounder there. And yeah, Michael's talented. Go check out his channel if you haven't already. He's great.
And we're going on the unauthorized use, but with the priors,
Yes.
it looks like, okay.
Yes, Judge.
And will your client waive the formal reading of the indictment?
Yes, Your Honor.
Thank you. See, Mr. Lamont, in cause number 231842, you are charged with the state jail felony offense of unauthorized use of a vehicle from July 14th of 2023. The indictment alleges you were previously convicted of burglary of a building, a second-degree felony, February 9th of 1990. After that was final, you were convicted of unauthorized use of a motor vehicle, a third-degree felony, October 31st of 1991, in 2 cases on that same date, making this for punishment purposes a second-degree felony. And how do you plead to that charge?
Yes, Your Honor.
And are those prior convictions true?
Yes, Your Honor.
I have here, and are you pleading guilty freely and voluntarily?
Yes, Your Honor.
And did you plead guilty because you actually did what they've charged you with?
Yes, Your Honor.
I have here on the computer some documents that have your signature on them that the state has marked as exhibit number 1. Before you signed these, did you go over them with your lawyer?
Yes, Your Honor.
Do you fully understand them?
Yes, Your Honor.
And do you understand, if I follow the agreement that you've made with the district attorney, that you will be waiving or giving up any right to appeal?
Yes, Your Honor.
Also, do you understand, if you're not a U.S. citizen, that a plea of guilty or no contest may result in your deportation, exclusion from admission to the country, or denial of naturalization under federal law?
Yes, Your Honor.
State tenders number 1. It's admitted. Is there any evidence that Mr. Lamont is not competent?
No.
All right, Mr. Lamont, I'm going to find that you entered your plea of guilty and true freely and voluntarily. Find that you're mentally competent and you understand the nature and the consequences of your plea. Find sufficient evidence to find you guilty, and at this time find you guilty of unauthorized use of a vehicle. Find those prior convictions true. Sentence you in accordance with your agreement to a term of 10 years in the Institutional Division of the Texas Department of Corrections. You will receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. I will sign a dismissal as part of this agreement in cause number 250234. I'm handing you the trial court certification that shows that this was an agreement that I followed, and so you have waived your right to appeal. I have also handed you a written admonishment regarding your ineligibility to possess a firearm or ammunition. Because of the judgment entered against you, you're ineligible under Texas law to possess a firearm or ammunition. Possession of a firearm or ammunition could lead to charges against you. Firearm is a legal term, and you should read the written admonishment I provide you to see what devices qualify as a firearm. If you have questions about the laws that make you ineligible to possess a firearm or ammunition, or about how long that lasts, you can talk with your attorney.
Yes, Your Honor.
Good luck to you, sir.
Good luck to you also. Have a good day, Purpose.
And thank you. Thank you, sir. Yes, sir. I'm signing that dismissal now.
Thank you. See you.
Okay, let's go back to Louisiana and try again, and see what kind of result we
Dixon
get.
Correctional Institute, that's who we're speaking to for the next hearing. We are at headquarters in Baton Rouge, and we've already introduced ourselves. You can see from our name tags of who we are, and we'll be conducting this parole hearing for Mr. Barry Johnson. Mr. Johnson, is that your name?
Yes, sir.
Okay, and what's your DOC number?
378093.
Okay, all right, first thing we're gonna do is we're gonna let you tell us what you did, why you're there, and why you're deserving of a chance to get out on parole. Then we're gonna ask the warden about your conduct since you've been there. And then we're going to go into, we have 3 people that are gonna be speaking on your behalf, and there's a total of 5 people that are willing to be present and supportive of you, and we'll read their names when we get to it in just a minute. And then Mr. Randall Meyer with the District Attorney's Office is going to speak. So first off, let's go ahead and get started. Mr. Johnson, tell us why you're there, how long you've been there, what you've done to rehabilitate yourself, and what you did as a crime.
Okay, as far as the crime, I made a foolish mistake, not a mistake. It was a bad decision, a poor choice I made. And I went in and I robbed a sports bar for some money.
Okay.
And since I've been incarcerated, I've attained my education. I started with the GED, took self-help programs. When the college courses became available, I took those as well. And right now I'm working as a high-set tutor at this facility.
Okay. All right, you've come a long way.
Yes, sir.
How long have you been in jail?
About 22, 23 years.
Okay. All right. Is that all you have to say about your statement as far as what you wanted to have your opening statement? We'll ask you questions in a little bit, but is that what you had to say?
Yes, sir. As far as going towards my rehabilitation.
Okay.
When I first came incarcerated, I realized the lack of an education always leads to people making poor decisions and poor choices. So in order to not make a poor choice or poor decision again, I had to educate myself.
Okay.
And that is what has caused me to make this turnaround in my life.
All right. Well, it's good to hear. I hope a lot of young people will get that message one day. That's good to hear. Warden, what kind of fellow has he been since he's been there?
He's actually, he came to DCI in 24. So he's been at DCI a little over a year in April of 24. But as far as his institutional record prior to that too, his low court write-up, last one was in 23, but his last high court was in 22. So since he's been at DCI, he hadn't had any in the year. He's been here. And like he said, as far as conduct, he's been good. And then he mentioned to me he got his education through the correction system, which is a good thing. He's also using that to help tutor our high set inmates here. So he hasn't given us any trouble.
Warden, you were saying, I was looking at that too. His last write-up was in 23 or 22?
His last low court, his last write-up was in 23, which was a low court write-up. We call it a Schedule A. And his last high court write-up was in 22, which would be a Schedule B.
So, okay, all right.
Okay, we're going to move on then. Thank you, Warden, for that. We'll move on to those in support of this parole. And the ones that are going to be speaking are Delbert Lewis, Joseph Johnson, and Berthel Lewis. And those that are at headquarters here but will not be speaking is Rebecca Andrews and Megan Andrews. So, Mr. Delbert Lewis, are you on the phone there? Mr. Lewis. You must be on mute.
Yes, sir. Yes, sir, I am.
Okay, good. Tell us what's on your heart and your mind there, Mr. Lewis.
Well, Barry Johnson is my nephew, and I have no doubt in my mind that when he is a free man, he will be a very good product to society. He will make an excellent citizen of the country. I know he has learned his lesson, and I know he's been incarcerated for a very long time. He's missed so much since he's been incarcerated. He's missed funerals, his grandmother's funeral. He's missed weddings. He's missed birthdays. And I think he now deserves a chance to prove to himself that he can survive and do well and be productive in this country, in this city. So
Okay.
I would pray that you consider him for parole and that you would make him a free man.
Okay. Thank you, sir, for those words, Mr. Lewis. And Mr. Joseph Johnson, the brother of Mr. Barry Johnson, would you tell us what's on your mind? You're on mute, sir.
I'm sorry, I'm Barry's older brother, and we talk every week. And you know what I mean? I think he deserves to be a free man. Like he said, he has got his education. We talk, we have big plans of things that we want to do. I have a trucking company, and we plan on him getting his CDLs, and after he's home a few years, he can come work with me. And that's been our plan. We be talking. He also took a CDL course in there that he was telling me about that he took in there. And I think he's ready for society, and I know he's going to do good. Thank you.
Okay. All right. And the final person to speak is Mr. Berthel Lewis, the uncle. Mr. Lewis, would you tell us what's on your mind?
Yes, sir. How you doing?
Fine.
Barry is my nephew. He's been incarcerated a many number of years, and as a minister of the family, as a pastor, I think he's been rehabilitated. He has a great support system that's supporting him, his family members, and all. And we miss him dearly. And it's my prayer that the Louisiana Board of Pardons would recommend him for parole. God bless you and keep you.
Okay, thank you, sir. We appreciate those comments. Mr. Johnson, excuse me, thank you, sir, for reminding me. Randall Meyer in opposition. I forgot you, sir. I'm sorry.
Oh, that's all right. I would have jumped in. Thank
Okay.
you, though. Randall Meyer, Assistant DA, Jefferson Parish. We're opposed at this time. I think Mr. Johnson is on the right path. I think he's doing well. I'm impressed with his educational work. I think that's extremely important. I'm glad he realized how important that is. But my opposition is based, number one, there's some victim opposition. He has a poor record under supervision. He was on good time when he committed these offenses. His disciplinary report is concerning. He's eligible for this parole hearing today by less than 1 month. In June of 22 is when he had that high court write-up, the end of June. Then September of 23, he had the low court write-up, which didn't make him ineligible for this hearing, but it shows that he continues to refuse to follow orders, and that concerns me. Looking at his history, I'd like to see him get some long-term substance abuse programming. His 95 arrest, he had about 36 rocks of crack cocaine and ingested about 15 rocks to try to avoid the arrest. He claims he was intoxicated at the time of the incident offense, so he doesn't remember the facts, except he claims that the gun that he used was plastic, not a real gun. I guess today I'm opposed. I would reconsider our position if he is denied today, if he gets some long-term substance abuse programming and he remains right up free. Those are my two big issues that I have. Thank you.
Okay. Thank you, sir. We appreciate your input. Also, Mr. Johnson, your case has been assigned as far as the lead and interviewer to Mr. Chuck Tillis on my left. And so, Mr. Tillis, would you go ahead and start the interview, and then the rest of us will pipe in when we need to.
Great. Mr. Johnson, you had problems with drugs. You were selling drugs or what?
In 95, I was selling drugs, but on this here, for this here particular charge, I took some pills.
You took some pills. So
Yes,
what was the situation where you robbed this sports bar? What were you needing the money for?
I didn't need the money, to be honest with you. I had just helped my uncle redo his roof, and he had paid me to help do his roof. It was just a foolish, stupid decision.
So you just went in and robbed this, you were high,
I had a relationship with the barkeep.
And you robbed her?
Yes, sir.
What was your reason for it? That's what I'm trying to find out.
There was really no reason.
I got you. So how long have you been incarcerated?
About 22 to 23 years.
That's me too. And you've done some extensive classes and stuff trying to rehabilitate
Yes, sir.
yourself. And that's good. What's happening with all the write-ups? Why are you getting proper?
The low court write-up, I was given a job as to start the prison newspaper, something I didn't know how to do. And the music helped me to focus on trying to get everything together. I got it together and ran it successfully for a year. They had music on the computer. That was the low court write-up. The high court write-up, it was a major shakedown, and 8 guards were shaking people down, and everybody was doing, all 7 of them were doing squat and cough. One of them said, bend at the waist and spread your cheeks. By the majority doing the squat and cough, I thought that was a proper procedure. So I refused to do it in that area because that particular search there, it can cause problems with other inmates. From what I learned, that particular search is supposed to be done in a closed area to where I'm not in the view of any other inmates. And since the other 7 were doing squat and cough, I assumed that was a proper procedure. When I made it to the cell block, I submitted to the visitor cavity search.
Okay. Warden, he hasn't given much problem there. He hasn't given much problems there.
No, so he's been here, like I said, April of last year, I believe, in the year, and he hadn't had any write-ups since he's been at DCI in the last year.
So he's following orders and doing he's following all the orders and stuff that you guys asked him?
Yes, sir. As far as I know, I don't know him all that well myself, but looking at the record, I would say he is.
Okay, thank you. I have no more questions.
Okay. Mr. Johnson, I'm not clear on what your plans are. If you were to be released, tell me where you're going to live, with whom, and what type of job you have lined up. I just want to make sure I understand clearly.
I plan to go live with my sister and her daughter.
And where do they live?
They live in Baton Rouge.
Baton Rouge. And where would you be working?
Whatever job I can get until I'm able to get on with my brother, till I can get my CDL to work with my brother, driving trucks.
Okay. That's kind of what I needed to know, is that you do have a solid plan upon release.
Okay, so have you been taking classes or going to, since you're a drug addict, have you been going to any classes?
I've completed substance abuse, but I just found out here about the class that they have. It's an open call out, and anybody could just go. But the job I have as a tutor, it takes up a lot of my time and my energy, because adult learners, everybody's different. So you have to individualize with each individual one. So
Go ahead, I'm sorry. Go ahead.
In the process of me trying to find out exactly what the substance abuse class is here and how to get in it, I didn't have the time to really find out really that it was just open call out.
When's the last time you did drugs?
Last time I did drugs, when I took them pills,
When was that?
2023, when I caught the charge,
23.
23, 24.
Now think back. I think it's 23.
I don't think so either.
What year was it?
Martin's looking it up.
Not
1995.
23,
You've been locked up 23.
2003, I'm sorry. 2003 or 2004.
Did you do them in 23 in prison?
No, sir. 2003 or 2004, I'm sorry.
Oh, we'll take the 2023 if you want.
No.
Sure. You haven't done any more drugs. Okay, I have no more questions. I have no more questions.
Okay. Any more questions for me?
I just will say that your transcript from Ashland, where you got your bachelor's degree, looks about like mine. So I'm in good company. I see some C's and D's in there.
Okay, I think that, I don't have any questions. I think we're prepared to vote.
Yes. I'm gonna vote in your favor today, to grant, but on the conditions that you get out, do some drug classes.
Okay.
I think that would be a help to you. Drug classes, Warden, when he's out, if he's out on parole, if the governor permits him to be out, I think he needs to continue drug classes.
Yes, sir. I'm sorry. Did you ask a question? It's hard to hear you. I'm sorry.
Okay, no, I was saying my vote is to grant today for him. And if he's released, it's on the basis of he continue or start drug classes. He's still a drug addict.
Yes, sir. Thank you.
Mr. Johnson, my vote is to grant parole. I will also stipulate with Mr. Tillis, a substance abuse evaluation and follow any recommendations by that organization. You know, it's in your court. This is the time you have to make the decision. So I'm going to give you that opportunity.
Okay, we got 2 votes to grant, and I'm going to go along with my cohorts here, and I'm gonna vote to grant your parole. But I hope that you're not a fella that is real educated but still stupid. Because you prove to me that way, if you get out and get back in trouble, then you're a well-educated, stupid person. Because you've had chances before, and you're getting a big chance now. So we don't want to see you back here. And plus, the victim said if they thought they were going to leave it up to the board, and if they thought the board thought that you needed another chance, then they're okay with that too. So because of that, you've received 3 votes today to be paroled, and there'll be some stipulations as far as substance abuse classes and AA meetings, things like that, that you got to stick with. But we're going out on a limb with you, okay? And so please don't disappoint us, and good luck and congratulations on your education and your reform.
Thank
you, sir. That's the end of the hearing, 10:30.
Well, would you look at that? An actual unanimous vote even. That's rare. I liked how the one guy was talking, though, about educated stupid people, because that is actually is a problem in society, in my opinion, is people who have all sorts of degrees but no common sense, it would seem. So I hope for his sake that he doesn't fall into that category and that he figures stuff out. I don't have a stinger for this, though. Michael, I don't want to give you more work, but if you're interested in making something like that, I have a vision, and that's for that dramatic kind of music coming in like you have in The Denied, but then for it to suddenly break apart, and then in disbelief, something like Approved? Just a thought. Take it, run with it, or don't. Again, I'm not going to make you do anything, but if you have a hankering to do something, I think that would be cool. Let's go to Judge Boyd. Let's see what's going on there. Let's make that happen.
Munoz the second, can I have parties announced?
Jason Garian for the state, Your Honor. Good morning, Judge Alfonso Cabañas for the defendants.
Are there any applications?
No, Your Honor.
Counsel, have you received all discovery? Did you review it with your client?
I have, Your Honor.
Court will find that the state is in compliance with discovery. Mr. Munoz, did you review the true bill of indictment with your attorney? Did you understand it?
Yes, ma'am.
Counsel, do you waive the reading of the indictment?
I do, Your Honor.
State, are you proceeding on the indictment as presented?
You are, Your Honor.
Sir, did you review the court admonishments with your attorney? Did you understand it and sign it in all the appropriate places?
Yes, ma'am.
You're charged with possession of a controlled substance, penalty group 1 less than 1 gram. That's a state jail felony. Range of punishment is anywhere from 180 days up to 2 years in the state jail facility and up to a $10,000 fine. If you have a plea bargain agreement with the state, the court does not have to follow your plea. If for any reason the court does not follow your plea and gives you more than you bargained for, the fact that you entered a plea will not be used against you and you will be allowed to withdraw your plea. Did you understand?
Yes, ma'am.
You have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call, and the right to remain silent. By entering this plea, you are giving up those rights. Did you intend to give up those rights and enter into a plea in this case?
Yes, ma'am.
Counsel, has your client been able to provide you with any defenses?
He did, Your Honor.
Do you believe he has a rational as well as a factual understanding of the charges against him?
I believe he does.
Do you believe he's currently competent and was legally sane at the time of the offense?
I do, Your Honor.
Mr. Munoz, has anyone threatened you, coerced you, or placed you in fear to get you to enter this plea?
No, ma'am.
Anyone promised you anything other than the plea?
No, ma'am.
Are you satisfied with the way you've been represented?
Yes, ma'am.
Are you a U.S. citizen?
Yes, ma'am.
Court will find that defendant has knowingly and voluntarily waived his right to jury trial. Did you review the plea bargain page with your attorney? Did you understand it?
Yes, ma'am.
According to the plea, punishment is to be assessed at 108 days in the state jail facility. There's a $2,000 fine, no applications. The state will take in consideration 2025 CR 005742 and 2025 CC 004950. Did you understand that to be the plea?
Yes, ma'am.
Defense, is that the plea?
It is, Your Honor.
State, is that the plea?
Judge, I just want to make sure I heard it correctly. That's 180 days.
Yes.
Okay, that is correct, Your Honor.
All right. And did you understand that to be the plea?
Yes, ma'am.
Did you review the waiver of appeal paragraph with your attorney? Did you understand it and sign it in both places?
Yes, ma'am.
Did you understand by signing that you're waiving your right to appeal? The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand? Counsel, have there been any such motions?
No, Your Honor.
Then to the offenses charged, how do you plead? Guilty, not guilty, or no contest? State any evidence.
Yes, Your Honor. State exhibit number 1 with office attachment. No objection to state's warrant attachment.
All right. State, you may be excused.
Thank you, Judge.
Did you review the waiver and stipulations with your attorney? Did you understand it and sign it in all the appropriate places?
Yes, ma'am.
Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call, and the right to remain silent?
Yes, ma'am.
Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports? But most importantly, there'll be no live testimony. Did you understand?
Yes, sir.
Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence states exhibits 1 and attachments, and the court will review the same. After reviewing states exhibits 1 and attachments, the court will find there is sufficient evidence to find you guilty, and the court will find you guilty. Are you proceeding with sentencing?
Yes, Your Honor.
Anything you wish to say on behalf of your client?
No, Your Honor.
All right, the court will find you guilty, sentence you to 180 days in the state jail facility, give you credit for any time served. There's a $2,000 fine, time and money to run concurrently. Take in consideration 2025 CR 005742, 2025 CC 004950. And I want to request the therapeutic community for you. It doesn't increase the time that you're in custody, but you really need help with your drug problem. You understand?
Yes, ma'am.
All right. Did you review the document entitled Trial Court Certification of Defendant's Rights to Appeal with your attorney? Did you understand it and sign it? Because this is a plea bargain agreement, because I followed your plea bargain agreement, And because you waive your right to appeal, you do not have the court's permission to appeal. Because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. If you have a question over what that is, you'll need to speak to an attorney. Do you understand?
Yes, sir.
All right, so we can go off the record. Here's the thing, using heavy drugs, only one or two things gonna end up happening. Either you're gonna end up in prison, in and out for the rest of your life, or either somebody's gonna have to identify your body. Now's the time, and I know it's probably difficult. I've never been addicted to drugs, so I know I don't understand the pain associated with it. I know it affects your brain chemicals and you get really endorphins and everything else from using. But you're gonna have to get a control of it. Otherwise, it's not gonna end well for you. When you're released from the state jail facility, if you need help finding a place for inpatient treatment, come back to here if I'm here, and I'll pick up the phone and call a place for you, okay? All right, counsel, on this, you're welcome. On this, some courts don't like for us to sign theirs, so I can't remember which county courts don't allow that or don't want that. I can still sign it, but I just don't like to step on any toes.
I understand, Judge.
So if for some reason they don't sign it, you can bring it back to me.
Okay.
All right.
Thank you, Judge.
Yes.
Okay, by a vote of 3-2, we're going to go to Judge McNally. But before we do, I do want to point something out. At 2 p.m. Eastern today, 11 a.m. Pacific, so about an hour after we end the live show, a video is going to post on the channel from Judge Middleton's court yesterday. And it involves a broken family, and broken by I mean like separated, their new significant others, a decent-sized fight, and Little League Baseball. So it's quite the story. I recommend you check that out. If you do not have notifications turned on for this channel, I encourage you to do so you know when we post videos. But definitely look for that one today. It's frustrating. And Middleton was frustrated as well. Anyways, let's go Judge McNally.
You got a warrant out. He's got a warrant out for.
I just see that, Judge. I'm gonna have someone pull it.
We're gonna adjourn this. Was there any no contact? Yes. So you got a GPS tether on, right?
Yes, Your Honor.
And you're not to have any contact with Shelley's agent?
Yes, Your Honor.
Who's got the phone here? Got to take the phone out of the building.
Phone off as well.
Whoever's phone went off, you have to go out of the building. Take the phone out of the building, please.
Whose phone went off?
I muted it.
I want you to take the phone out of the building. I'm sorry. This goes on too much. Get the phone out of the building. There's signs all over. I'm sorry.
Your phones are off.
That's why I did that. But I'll go put it away.
Thank you. All right, so we're going to adjourn this pre-trial. And how long do you have for me, Heather or Lisa?
That will be for July 22nd at 9:30.
Is it possible that we could put it next week, Heather?
Guys, tell me, is this phone again, or is this phone again as in we've seen this part? Because it's possible that where I was in this feed got reset a little bit. So let me know if I'm off here. We'll move on to something else.
All right, so you'll go down the hall, sir, you'll get your notice, and you have to wait for the other warrant, okay?
What do I have a warrant?
I don't know, they're gonna pull the file. I think it was a public order crime, I'm not sure though, I didn't look. Okay?
All right, thank you.
Have a seat behind you at the table. Is Ms. Fanning out there yet on the other case?
Okay, apologies. Sometimes, I've made it no secret, we're always a little bit behind the feed. That way I can queue stuff up easier. But sometimes as you're flipping through, stuff gets reset. Let's go to Judge Boyd, because I know we haven't seen this, and I'll move forward in McNally. Again, apologies.
The first time I've needed a judge to bail me out. Never trust a lawyer.
No, and that is so wrong. I remember one time I was trying a case, and on the civil side, they do time announcements, and the announcement was for 4 weeks. Every single day, that judge on the criminal side was Are you in trial? It's a 4 weeks, I'm in trial, I'm in trial. So if you need me to call that judge or anything, just let me know. All right, the court is calling 2025 CR 003824 and 2025 CR 003825, State versus Christopher Anthony Mazuka Garcia. Could I have parties announced?
Duffy Pitlock for the state of Texas, Your Honor.
Michelle for the defendant, we're ready.
Just a second. Excuse me, counsels, if you all could move from behind the court reporter. And we're back on the record. And are you Mr. Garcia?
Yes, ma'am.
Counsel, have you received all discovery and did you review that with your client?
Yes, Judge.
And has discovery acknowledgements been tendered in this case yesterday?
Yeah.
Okay. And each cause number, the court will find that the state is in compliance with discovery. And each cause number, did you review the application for deferred adjudication or community supervision with your attorney?
Yes, Your Honor.
Did you understand it and sign it?
Yes, Your Honor.
Did you review the true bill of indictment with your attorney? Did you understand it? Counsel, do you waive the reading of the indictment in each cause number?
Yes, Judge.
State, are you proceeding on the indictments as presented in each cause number?
No, Your Honor, we are not.
All right.
A motion to reduce to a third-degree felony attempted assault peace officer.
No,
In-
Judge.
In each cause number?
In each cause number, Your Honor, yeah.
Any objection?
No, Judge.
In each cause number, did you review the court admonishments with your attorney? Did you understand it and sign it in all the appropriate places?
Yes, Your Honor.
In each cause number, the state has asked that the charge be attempted assault of a peace officer or judge. That is a third-degree felony. Range of punishment is anywhere from 2 to 10 years in prison and up to $10,000 fine. If you have a plea bargain agreement with the state, the court does not have to follow your plea. If for any reason the court does not follow your plea and gives you more than you bargained for, the fact that you entered a plea will not be used against you and you will be allowed to withdraw your plea. Did you understand?
Yes, Your Honor.
In each cause number, you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses. The state would call in the right to remain silent. By entering into these plea bargain agreements, you're giving up those rights. Did you intend to give up those rights and enter into a plea in each of these cause numbers?
Yes, Your Honor.
In each of the cause numbers, did you understand if the court were to grant your application for deferred adjudication, if for any reason your deferred adjudication were revoked, the court could find you guilty and sentence you up to 10 years in prison and up to a $10,000 fine?
Yes, Your Honor.
Counsel, in each of the cause numbers, has your client been able to provide you with any defenses?
Yes, Judge.
Do you believe he has a rational as well as a factual understanding of the charges against him?
Yes, Judge.
Do you believe he's currently competent and was legally sane at the time of the offense?
Yes, Judge.
Mr. Garcia, in each of the cause numbers, has anyone threatened you, coerced you, or placed you in fear to get you to enter the plea?
No, ma'am.
Anyone promise you anything other than the plea?
No.
Are you satisfied with the way you've been represented?
Yes, ma'am.
Are you a U.S. citizen?
Yes.
In each of the cause numbers, the court will find that defendant has knowingly and voluntarily waived his right to jury trial. In each of the cause numbers, did you review the plea bargain page with your attorney? Did you understand it?
Yes, Your Honor.
In each of the cause numbers, according to your plea, the state is proceeding on the lesser included offense of attempted assault of a peace officer. They're recommending deferred adjudication. The cases were run concurrently. There's to be no contact with the complainants. Did you understand that to be the plea? Defense?
Yes, Judge.
State?
Yes, Your Honor.
Did you review the waiver of appeal paragraph with your attorney in each of these cause numbers?
Yes, Your Honor.
Did you sign it in both places?
Yes, ma'am.
Did you understand by signing that you're waiving your right to appeal? The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Yes, Your Honor.
Counselor, there be any such motions?
No, Judge.
Outside the agreement, the state is recommending that your community supervision be for a term of 3 years. There be a TAP evaluation, 100 hours of community service restitution, no contact with the complainants, and anger management. Did you understand those are recommendations from the state and the court does not have to follow those recommendations?
Yes, Your Honor.
Then in each cause number to the lesser included offense, how do you plead? Guilty, not guilty, or no contest?
Guilty.
State, in each of the cause numbers, do you have any evidence to support the defendant's plea?
State offers State's Exhibit 1 and all attachments into each case respectively.
Any objections?
No, Judge.
All right, state, you may be excused.
Thanks, Judge.
In each of the cause numbers, did you review the waiver and consent to stipulation of testimony with your attorney? Did you understand it and sign it in all the appropriate places?
Yes, Your Honor.
Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state will call and the right to remain silent? Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports, but most importantly, there'll be no live testimony? Did you understand?
Yes, Your Honor.
In each cause number, the court will find that the defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence states exhibits 1 and attachments and review the same. All right, in each cause number, the court will find there is sufficient evidence to find you guilty. The court will defer finding of guilt as you've applied for deferred adjudication. Are you proceeding with sentencing?
Yes,
Anything you wish to say on behalf of your client?
I urge you to follow the plea recommendation. The state tell us in negotiation that if he behaves himself, they would not oppose his application for early termination at half term.
All right, so Mr. Garcia, do you have a place to stay?
Yes, ma'am.
All right, do you live there by yourself or with someone else?
I live with my girlfriend, my mom, my dad, and my grandparents.
All right, are there any minors in the home?
Oh, ma'am.
All right, so why were you at a homeless encampment? What was going on with you then?
Honestly, I'd lost a good friend at that time, and I just recently lost another one a few days ago.
I'm sorry to hear that.
And I was kind of going through it with my parents, and we weren't agreeing on things. And I kind of just wanted to be away from everybody where I wasn't having a lot of people around me, so I kind of stayed in the forest.
All right, and if you're drug tested today, what will the results be?
Obviously.
All right, so here's the thing. If you have a drug issue, now is the time to tell me, because I'm going to accept your plea bargain agreement to place you on probation, but I'm trying to figure out what would be good conditions to give you. I don't do cookie cutter conditions. I look at each person as an individual. So I'm trying to figure out what you need. So if you're going to test positive today, that's not a violation of your probation because you're not on probation. You understand?
Understood.
So tell me about yourself. Are you going to be clean?
I should be clean, yes, ma'am.
All right. When's the last time you used and what did you use?
There was a store that had a little concession stand. They had these vapes.
So you're just saying marijuana?
Yeah. And I really don't even like it. I was just, and then the moment, hey, try this, I would say if you like it. And I was like, okay, but I have a kind of thing against drugs.
All right. Have you ever had any mental health diagnosis?
Yes, I was a foster kid.
All right. And what was your mental health diagnosis? Do you?
PTSD. I was considered bipolar at one point. I had a ADHD, and then I don't know the rest of it.
Mr. Garcia was, he's adopted. He was abused as a child. He's seen a lot.
Okay.
You don't have the videos in front of you, Judge, but if you watched it, he was scared. And I think that trauma has carried forward as an adult. So I would recommend, some type of mental health counseling. You're not going to have any problems as far as drugs with them. THC, you have no idea what's out there being sold, but I've never suggested or thought that he was under the influence of alcohol, methamphetamine, cocaine. He's not doing any of that kind of stuff.
It's for my daughter, honestly. I really don't want to ever have to deal with a father that's not alive because of substance I took in.
Okay. And do you have any children?
Do I have a daughter?
How old?
She's 5.
All right. Have you had contact with her?
For the first time I hear this, that's here 3 times this month.
Okay. All right, this is what the court is going to do. In each cause number, the court is going to sentence you to 3 years deferred adjudication. They will run concurrently. There's to be no contact with Jonathan Cokerham, Cokerham, and Christian Benavides. 100 hours of community service restitution. I'm going to order parenting classes. Once you complete that, the restitution hours will be deemed satisfied. There's to be no unsupervised contact with minors. So here's the thing. You can still see your daughter, one of your parents, your mom or somebody needs to just supervise it. Once you complete parenting classes, your attorney can come back and I'll consider lifting that. All right. There's going to be regular reporting by Zoom or in person. There's to be regular random UAs, proof of employment within 30 days, no employment as a home health care provider or with minors, field visits 1 time per month for 6 months, MIC evaluation out of custody, CAP evaluation out of custody, follow recommendations. If the recommendations include inpatient treatment, we'll have a conversation about it and we'll see what's the best fit for him. And I'm going to run a referral to mental health court. State, do you have any objections if mental health court were to accept him, that there be a motion for new trial filed?
No, Judge.
All right, so mental health court will not take him if he's on probation. So we'll do a referral to mental health court. I think they'll be able to address all his issues. And then if they're accepting of him, then you come back with the motion for a new trial and this will be taken off. Probation, is there anything else?
No, Judge.
Is there anything else you need from the court to be successful? All right, did you review in each of these cause numbers the document entitled Trial Court Certification of Defendant's Rights to Appeal with your attorney? Did you understand it and sign it? Because this is a plea bargain agreement, because I followed your plea bargain agreement, and because you waived your right to appeal, you do not have the court's permission to appeal. Do you understand? All right, we can go off the record. Here's the thing. Oh, and I'm sorry, probation, I really don't see this as an anger management issue. I think there are other mental health issues that are causing certain behaviors. So that's why I didn't order anger management. If for any reason you have an issue, you feel that you need some help, just let your probation officer know, okay? All right, good luck to you. You're welcome.
So I have excuse.
Yes.
Okay, now let's go over to Judge McNally. His phone situation was so bad we had to listen to it twice, but now we have something new.
I need Emily. So he's going to plead to both charges?
Yes, sir.
Is that what you want to do, sir?
Pardon?
Is that what you want to do, is plead guilty to both charges? If you do, I'm just telling you the maximum could be 10 days. These are 2 technical violations. You don't have any priors. You can get 5 days jail for each technical violation, so you could get 10. Do you understand that?
Yeah.
And did you sign, read, and understand the advice of rights?
Yes.
If you plead guilty, you'll be giving up all those rights, and there will not be a hearing or a trial. Do you understand that?
Yes.
All right. As to count 1, that you failed to submit the monthly testing as ordered on May the 12th of 25, how do you plead?
Guilty.
Did you fail to submit the testing that day?
Yes.
As to count 2, that you failed to submit the testing as ordered on June 17 of 25, how do you plead?
Guilty.
You failed to submit the testing on that date.
Yes.
Anybody forced you to plead guilty?
No.
Please accept it to both counts. What is going on here?
So he called both of those days. I do have the screenshots with his phone calls. He called at 6:03 a.m. on May 12th. He called at 5:05 a.m. on June 17th. He also called his probation officer and did take retests. I believe it was either that day or the next day. He really is unsure how this happened, but he's taking responsibility for the fact that it did happen. I'm gonna make sure he knows his right color, that he knows what to do if this ever happens again. We don't expect it to happen again. He has been calling numerous times now to make sure that he's not missing. He's been calling at least 3 times a day. but he's not drinking alcohol. He did have significant injuries from this issue.
From the accident?
Right. He just graduated to a cane from a walker. Unfortunately, while on probation, he did lose his wife. They had been married for 51 years.
Oh, geez, I'm sorry.
In late December. So he has been dealing with that. But it's really more of a oversight in a sense, because he has been calling. He did take a retest. He's not drinking alcohol. He's been doing his community service. If anything, I'm asking that the court add some more community service.
Emily Tessito?
Did he take retests on these?
He did, but not the day after. So, the one for May, I kind of given him an opportunity to go again. He went the 20th, and then he missed again the 17th, obviously, and then he
The
called.
20th of May or the 20th of June?
So for the May one that's on there, May 12th, he didn't go till the 20th.
Well, that doesn't do any good.
And then this June 17th, he got the notice and called me. So he kind of took initiative to go July 1st.
How often did I order testing? Month?
Just monthly. He's been decreased on monthly.
He's what?
He's been decreased. It wasn't, he didn't start it as monthly. He's now at monthly.
And I swear on the Bible, I do not drink.
Oh, I know. You're not going to be the first guy that's told me that.
I know.
I just need some proof here, okay? And the only way to get proof is to have you test. Is DNA open today?
Yes.
You're going to test today. You gonna be negative?
Pardon?
Are you going to be negative? I'm
Yes.
ordering you to go test today.
Yes, definitely.
Is there anything
I'm
you,
on medication though.
is there anything you'd like to say?
Me?
Yeah.
Oh, man, I know I'm having a hard time dealing with my grief on top of everything else.
No, I can understand that. I feel bad for you.
I just can't imagine how I missed my color.
All right. You tested DNA
On my
today.
phone now, you can see I call numerous times every day because I don't want to make the same mistake again.
Defendant to serve 5 hours community service additional to be completed by July the 11th, July the 21 rather, 31 rather, sorry. Be completed by July 31. You tested DNA today. You pay additional costs of $50 today. So you can pay $50 with 5 hours of community service by July 31. Tested DNA today. If you miss another test, I'm going to extend your probation.
Okay.
Okay? I'm going to have to extend your probation.
Now on the community service, what's my total hours I gotta do?
I'll look at that.
She'll talk to you about all that.
I can only do 2 hours.
Yeah, we'll talk about that.
Okay? All right, he doesn't have his community service done yet?
He had a medical. He just got his cast off.
I
He
see.
had a lot of work ethic training.
Right. I got it. Okay, I'll let you work with her. Good luck.
Thank you, Your Honor.
Thank you. Julian Geisig. This is 24W 835467. Mr. Mohammed, do you have Mr. Dugan's file?
Your Honor, I turned it in.
Where is it?
I believe it's a
Okay.
waiver and there's no objection.
Okay. Name?
Good morning, Your Honor. Let me give you 550 on behalf of Mr. Who's to my right.
Sir, your name? What's he going to do here, counsel?
He is gonna plead guilty,
All right, if you plead guilty here, this would be, again, if you plead guilty to both counts, that'd be 4 violations. You could have your probation revoked and you could be jailed for up to 45 days. This is an attempt larceny. Do you understand that?
Yes, sir.
And did you sign an advice of rights and read and understand the rights today?
Yes, sir.
You plead guilty, you'll be giving up all those rights and there will be no hearing or trial. Do you understand that?
Yes, sir.
Is the count one that you failed to attend the court work program on June 21? How do you plead?
Yes, sir.
Did you fail to attend the court work program on June 21?
Yes.
Count 2, keep your voice up nice and loud, to the charge you failed to enroll in the positive strategies program. How do you plead?
Guilty.
Did you fail to enroll in that program?
Yes, sir.
Anybody forced you to plead guilty? Please accept it. So I ordered this March 5th. I gave him 4 days on the court work program, ordered him to do the positive strategies program with 8-week follow-up. Mr. Nahikian, what do you have to say?
So for the court work program, he just had one left, it's my understanding. He did have a doctor's appointment on 6/21. He can provide verification to probation. I think he notified probation of this, but he didn't provide verification. Obviously, court work program comes first. He needs to make sure that his scheduling is all around that. I had a good conversation with Mr. Geisig about taking responsibility, making sure that a lot of these things are on him. He was unaware of how to sign up for the positive strategies program, which again falls on him. I made that clear that, hey, if this happens or something you haven't done or something you need to do, call probation. They're going to answer, at least make a record of you attempting to do these things. So I think he has a better understanding of that. I don't see these issues reoccurring again. I do think he's taking this serious and he understands that, hey, jail is a real possibility. So we're just asking that he be allowed to re-enter that positive strategies program. That support work program days are added. He did have 4 previously, he has 1 left. So we're asking that he have more court work program days that he be allowed to continue on probation.
Your name?
Emily Casino.
Anything you'd like to say, sir?
No, I honestly don't know.
You gotta grow up. What do you want to say?
I would agree. I did reschedule, the alleged doctor's appointment was May 31st. And I did reschedule him for June 21st. And then he missed that one. And then I didn't include it, but he missed our probation appointment on June 16th also.
You're gonna end up in jail if you're not careful here. What are you doing?
Honestly, I just be at work losing track. Like,
What do you work? Where do you work?
I'm certified rescue safety.
A what?
Rescue safety.
Who do you work for?
Ace Industrial. We're contractors.
How long did they put him on probation for? What do you think?
I think he needs to get organized because I do feel like I'm chasing him.
So I understand. I kind of had that sense from you before, if you don't mind me saying. I don't want to sound mean or anything, but I just had that sense from you the whole time on this case. I'm telling you, that don't push me any further, okay?
Yes, sir.
Serve 1 day on the court work program additional, pay $35 for that, pay additional cost of $100 to be registered for positive strategies program. Any reason you can't register next week, by the end of next week?
No, I can't.
You register for that by July 18th and attend that program. Do you understand?
Yes, sir.
All right, last chance. Can you pay the $135 today?
Yeah.
Come on. You gotta grow up, son. All right?
Yes, sir.
Good luck. Thanks. People against spite.
All right, let's finish the day off with one more try in Louisiana. Let's see if we can go 2 for 3.
Still the 8th of July. We've had several hearings this morning. We're at headquarters in Baton Rouge. You can see by our name tags who we are. We're on the committee on parole this morning. And we'll be deciding about your future and taking action on this request. We're speaking to Dixon, and we appreciate you hosting us again there, Warden. The way we're going to do this, Mr. Danton, is that we're going to begin by asking you to explain why you're there and what you've accomplished since you've been there, and try to convince us that we should take a chance on paroling you. Then we're going to ask the warden to give us a little bit of background on you. Then we're going to allow your daughter's going to make a brief statement about why we should release you. And then we're going to ask questions, then we'll take a vote. It's a real simple process. So let's go ahead and get started. If you would, Your name is Dudley Danton. What is your DOC number, Mr. Danton?
5375.
Okay. Tell us why you're there, what you did, and what you've accomplished since you've been there in the way of rehabilitation.
Been doing good. I never got no write-up since I've been here. And,
Okay, no write-ups. Good.
I do what they tell me to do, whatever.
Yes, sir. That's a good thing. No write-ups. Have you taken any courses there that you want to tell us about?
Yes, sir. I took took some classes and all. I took all the classes they got me to do, I did them all.
Okay. All right. Warden, what kind of fellow has he been since he's been there?
He's been here since 2013, it looks like. He had no write-up since he's been here, so he stayed out of trouble while he was here for sure. Really, the class I think he's trying to say is he took the sex offender treatment classes.
Yes, that's what I assumed. I was hoping that's what he was saying.
Yes, and he's taken a few other classes, but that's the one I believe he was trying to mention. But he hasn't given us any trouble, no write-up since he's been here.
Okay. All right, Miss Christy Gaspard, you are the daughter of Mr. Dudley Danton. Would you tell us what you'd like us to know?
Sir.
You can just, okay, you can sit there or.
He has done 13 years. I really believe through the conversations him and I have had that he is very remorseful for what he has done, and he has repented for his sins. And I know he's really sorry for what he's done. It's not just sorry that he got caught. I know he's a better person than he was before, and with God, all things are possible, and he has God, and I know he has Parkinson's. He can't do anything. He can't even walk. So we're just praying that he could come home to us so we could take care of him.
Okay. Thank you. We appreciate that. And just so you know, I'm sure you know, but Lewis Mathern is with you also there behind you, but I think you already know that. And so she chooses not to speak. Okay. The interview is my responsibility. This particular one was assigned to me. And so I'm going to ask you a few questions, and my cohorts up here will get a chance to ask you some questions. Talk to me a little bit about the crime. Can you tell me what you did and why it was such a mistake?
I thought the girl. I don't know why, but I did. I'm sorry about that.
Could you hear him?
No, I can hear the noises, but I can't understand anything.
Can you speak a little louder?
I thought it was a girl. I'm sorry I did, but I don't know why I did, but I did.
Did you catch that?
Don't know why you did it, but you did. Is that what I heard?
Yeah. He said he touched the girl. Don't know why he did it, but he did.
Okay. And you were 60 years old when this occurred, correct?
Yes, sir.
Okay, and you got a total of 18 years for this indecent behavior situation, correct?
Yes, sir.
With a juvenile. And she was under the age of 13, I believe is what we saw from the record. And you got an 18-year sentence and a 5-year sentence to run concurrently. And of those 18 years, you've served 12. Is that correct?
Yes, sir. 13.
Okay. All right. Mr. Tillis, questions?
I have no questions.
The 28. 13 of it.
I would like to make note that there were 3 victims, and this was pled down from sexual battery initially.
Okay. All right. We appreciate that. And you've got some opposition from the DA, the sheriff, and the attorney general. The fact that there were other victims. You did plead guilty, and we do have victim opposition. And you hadn't taken a whole lot of programs or classes. And so these indecent behavior with juvenile cases are really, really problematic for us. And so it's my responsibility to vote first because this case was mine. And my vote is that we're going to deny this request for parole due to the age of the victims, due to the number of victims, and due to the fact that you've only served 12 of 18 years, which is a reduced from what it really was anyway. So that's my vote. Mr. Tillis?
My vote is to deny also.
My vote is to deny based on victim law enforcement opposition, age of the victim, and it was a plea.
Okay, thank you, Ms. Ledoux. I'm sorry to tell you this, Mr. Danton, but your parole today has been denied, and that's the end of the hearing. It's 10:48 in the morning.
Denied.
Well, there you go, friends. We might have still ended on a happy note, depending on how you look at it, because as I mentioned in the chat, I'm not sure what it is with old men touching children, but there's a lot of it, and it's never made sense to me. But this is why we have a legal system, and they deal with this stuff for us. So maybe it was a positive outcome, because maybe he's right where he needs to be. But that's something that we can, I suppose, debate as life goes on. We'll go ahead and leave it there for today. I will remind you at the top of the next hour, I do have a good video posting from Judge Middleton involving a broken family and a Little League baseball game and a bunch of mayhem. So it's worthwhile. Be sure to check that out. But we'll be back tomorrow, 10 a.m. Eastern to 7 a.m. Pacific, a half an hour early for channel members. If you're lurking out there and you're not a channel member, go to the pinned chat, click on that link and become one. Trust me, you'll like being part of that community. We have a lot of fun, made a lot of good friendships, a lot of good cooperation, people always helping each other. It's a great place to be, so be sure to check it out. And it doesn't cost hardly any money either, so it's worth it. Anyways, we'll see you tomorrow. I hope you all had fun today. And I got to figure out what to do with myself until I see you guys again. But until then, take care. God bless.